No confidence motion of a municipal board, my lord. So let it come on 12th, my lord, for vacating the interim order
You want the matter to be listed.
on 12th.
Why?
My lord, to vacate the interim order.
So you have filed a stay vacating.
There is no, my lord, that can be, we've already taken the plea, my lord, there was some, can be disposed of with two line order. Holding of the, my lord, motion.
Okay. We'll have it on 12th.
Yes, obligation.
Wait, look. He said I filed a writ petition regarding disconnection of electricity. So disconnection of electricity, man. So may be taken on Monday.
When?
Monday, man. How like it?
My lord, I also mentioned it yesterday, but due to some technical error that cannot be registered, my lord. It's a writ petition, it's against an e-auction, my lord. And matter needs to be heard on urgent basis, otherwise they will forfeit our EMD money, my lord. It's an unlisted,
Today?
today, my lord. All right.
Oh, well, in Poland.
Extension, I did not 27, the petition has expired, so I need to make that substitution.
Date certificate?
That I'm obtaining, that information has been, the information has been furnished that he has expired, that's the I'm obtaining, so I filed an application for substitution. I've been telephonically instructed.
Matter pertains to?
Lord, the PWD, my lord, payment only 8 lakhs rupees remain, my lord. Other payments have been made.
Non-payment.
Non-payment contract has been.
Mr. M. Dutta, the learned counsel appearing on behalf of the petitioner submits that the petitioner, that he has been informed that the petitioner had expired and as such would like to make appropriate application seeking substitution. Taking into account the above, list this matter up to 4 weeks.
May it please the lordship.
Taking into account the above, list the matter only upon application being filed for substitution of the legal heir. It is observed that if the application is not filed within a period of 6 months, the matter will be again listed before.
Lordship, in item number 32, I have filed an additional affidavit. Let me kindly be called.
Lordship, similar prayer, Lordship, in item number 53 and 54, Lordship, we have filed an additional affidavit.
I beg to mention item number 12 and 13, but I may be 12 and 13, my
30.
lord. 12, 1, 2 and 13, 12 and 13.
Hmm.
My lord, I may be allowed to withdraw the petitions.
Your name?
A. Ali.
Mr. A. Ali, the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the writ petition. Accordingly, the writ petition stands closed on withdrawal. Ms. Udas, you appear? Ms. Udas appears on behalf of the Fishery Department of the Government of Assam. And the next one,
12 and 13, my lord.
your name?
A. Ali.
A. Ali 32.
My lord.
32 is not your
32,
name, is there?
Not 13, my lord, 13.
13.
12 and 13.
13 also, same order.
Say what? My lord, liberty.
No liberty. What liberty? No, no liberty.
My lord, there is a mistake. This matter has already been listed for Monday, but we are requesting for the urgent listing, my lord, because today we filed it and we got the registration number, my lord.
Okay,
My lord. Today, my lord.
it's listed on Monday.
Yes, yes, my lord.
Okay, we'll mention it. I'll take it up today.
Obliged.
Twenty and 23. Item 20 and 23, Lordship.
20 and
23. Conducting counsel, Mr. Theophane is out of session. His father is
20 and 23. What is there?
Lordship. I was instructed to adjourn the matter for that day. The conducting counsel is out of station. His father is hospitalized.
What has happened? Father is hospitalized. Whose father?
That's his father.
Which council? There are 3 councils.
Nyauddin.
What about N Hawk? He's the lead counsel. Ask him to appear. Chal. Next.
For motion item 1.
Right, please, Your Lordship. This contempt petition has been filed for non-compliance of judgment and order dated 3rd March 2025, passed in WBC number 7999 of 2022.
Direction given to whom?
My lord, there are 10 respondents, my lord. All the respondents were directed, my lord. At page 16, my lord. Para 10, in view of the respondent authorities are directed to pay the aforesaid outstanding amount of rupees to ensure.
Now
Only
tell
within-
me, how within 5 months a payment can be made? Following comes here.
My lord,
Now
that
tell me,
I-
how is it possible?
my lord,
Possible?
my lord, the both cannot possible, my lord. That's I have confused, my lord.
The order is very defective.
Yes, my lord, in that sense, my lord.
Amsar Ali categorically says he will be put in a chronological list.
My lord, it can be considered in other angle, my lord. The bill.
You have to come up with a case that you have not been put in the chronological list even after 5 months. Is it your case?
Yes, my lord. Otherwise also, my lord, if Tamsir Ali followed, my lord, my bill pending since 2020, my lord. Since 2020, if they
No,
followed
first they
Tamsir
have
Ali,
to
my lord.
verify and then put it in the chronological list.
Yes, my lord.
You approve, if the bills were pending for that period and you have approached this court when?
22, my lord.
22.
Yes,
So
sir.
obviously the order was passed in the year 2025.
25.
So obviously it cannot be. So you have to be put bottom in the list, in that 2020 list,
Uh,
isn't it?
maybe, my lord.
That is not maybe, that is the only way out.
My lord, how long the list
So you
is, I
have to
don't know,
come
my
up-
lord.
you have to make out a case as to whether it has been verified or not. Verified and found out.
My lord, the amount is admitted. Para 7 and 8 of page 15, my lord. Reflect it.
Where is the BTC council? Get hold of a BTC council, will pass an order.
Like it.
I believe. My lord, this is, notice was issued, an interim order was given. It relates to one of those cases, my lord, stone quarries, which are also dealt with. The interim order was, my lord, to allow the extracted material, because they have taken the advance money, my lord. And we started operating because all the statutory clearances were given. And thereafter, my lord, they were not doing it, and therefore we had to come and before our lordship.
What
Because
is the order you, what is the interim, having heard?
interim
the
order is
will
at
have
page
allowed
18, my lord.
The demand are all mandatory, except parents. So they are not allowing you.
No.
No, no, they have formed a
Which
committee.
department?
What they have done, we wrote to them 2 letters, which we have annexed, my lord. This was on 3rd of, 5th of September. 8/9 and 18/9 we wrote. Then they now, my lord, have given a letter. A committee was formed to assess. And which is unknown there, because the procedure is, my lord, we are required to pay in advance royalty. And then we extract, and then when it is taken, then they give us the challans. And we take the thing, and in chalan, they determine the quantity by the truck we are going. Some trucks are 10 meter and all that. And then they have a list, and we are given a list. And that is how the procedure is prescribed by them. Now here, in order to defeat the purport of the order, they have constituted a committee to assess, and then they make an assessment. And after, my lord,
But Mr. Goswami, why have you made the additional chief conservator, principal chief conservator of forest as a party?
You are the main for Karbi Anglong, he is.
Have not made, but you have made the principal chief conservator of forest as a party, but this order have not been forwarded to the principal chief conservator of forest.
No, we have given.
He is a party, my lord.
No, he is not a party. You have made only the principal chief conservator of forest as well as the divisional forest officer.
Between Banchal is the
Annexure
Page
2
21.
and Annexure 3. And the person who has done this, from that particular past that order is also the additional
21.
principal chief
21 to some-
conservator of forest.
Just
think
give me
it's
a
a
minute, give me a
unique-
minute.
21 to some- between Kumar Banchal and this is-
Page 21.
I think he's the additional principal chief conservator of forest, not the principal
Additional
chief.
PCCF come CHD Forest, Bipin
He-
Kumar Banchal.
So
That is
he
his
not the
order.
Principal, it has to be additional. It seems to be something mistake.
Additional, your lordship is right. At
Page
page
2,
21.
it should have been additional.
Yes,
Huh? এটা কি করি তো এটি?
না, between Kumar Banchal party বানাইছো,
হ্যাঁ।
page 2 কিন্তু additional photo কি
He is not the principal, your lordship is right. I didn't notice that, additional PP.
You know, let us issue notice
Huh.
and you file a fresh memo of parties,
Yes,
making the necessary correction.
correct.
Heard Mr. P.K. Goswami, the learned senior counsel assisted by so-and-so appearing on behalf of the petitioner. Mr. Goswami, the learned senior counsel at the outset submitted that there is a mistake in putting the designation of the respondent number 1 in as much as his designation is additional PCCF come CHD Forest Karbi Anglong. Gustav. Taking into account the above, the petitioner is given is directed to file a fresh memo of parties before the registry of this court within 3 days. Showing the respondent number 1 as the additional PCCF come CHD Forest Karbi Anglong. And on the basis of the said memo of parties, the registry shall make necessary correction in the cause title as well as also update the same in the CIS. This is an application filed alleging willful and deliberate violation to the order passed by this court dated 5/9/2025 in WPC number 5203/2025, whereby this court had categorically directed in the interim that the petitioner shall be permitted to remove the already extracted stones from the designated area of stone quarry at Napu Pani, Monsa Enki number 1 stone MC area. Gustav. The learned counsel appearing on behalf of the senior counsel appearing on behalf of the petitioner has drawn the attention of this court to the various communications issued to the respondent number 1 and 2. And the respondent number 1 and 2, in spite of that, have not permitted the petitioner to remove the already extracted stones.
Correct. What they have done,
The
my lord,
learned senior counsel also further draws the attention of this court to the order dated 19/9/2025, whereby instead of adhering to the directions so passed by this court, the respondent number 1 have formed the committee. The learned senior counsel therefore submits that this is an out and out willful and deliberate violation to the order passed by this court dated 5/9/2025 in WPC number 5203/2025. Taking into account the above, this court therefore issues notice upon the respondent number 1 and 2. Steps be taken by speed post. So additionally, the petitioner is also granted the liberty, additionally, the petitioner shall also, is granted the liberty to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. Issue notice making it returnable on 15th of December.
well, we have additional affidavit also filed, that has not come possibly. We just had 2 letters, so we annex that.
That is okay, but we have, I made it, I think this will
Yes.
be enough.
Item.
Yes, yes, yes. Right. Give a copy. You see, there is a direction to make payment
Lordship,
within a period of 5 months, but following Kamseral. Obviously, that order cannot be complied. Taking into account both cannot go side by side. But the fact remains that whether you have put it in the chronological list after verification is
Yes.
the issue.
fine.
If you find out that, we close the contract.
Lordship,
So I'm only requesting you to appear to get that instruction. After that, if I find that yes, a case is made out, then only I issue notice. The instant application has been filed alleging willful and deliberate violation to the order passed by this court dated 3/3/2025 in WPC number 7999/2022, whereby the learned coordinate bench of this court had directed the payment of rupees 26,19,218 within 5 months from the date of receipt of the certified copy of the order by following the judgment of the learned food bench of this court in the case of Tamser Ali versus State of Assam, reported in 2008 for a GLT 1. It is very pertinent to take note of that in terms with the judgment of the Supreme Court of the learned full bench of this court in Tamser Ali Supra, the direction so passed therein is that after carrying out necessary verification and finding that the particular person is entitled, particular contractor is entitled to any amount, the said the amount, the name of the contractor would be put in a chronological list, and on the basis thereof, the payment would be made. Full stop. Under such circumstances, this court therefore requested Ms. B. Bhuya, the learned senior counsel who also appears on behalf of the BTC, to apprise this court as to whether the necessary as to whether the mandate of the judgment of the Supreme Court in the case of Tamser Ali of the learned division full bench of this court in the case of Tamser Ali Supra have been adhered to in terms with the directions passed by this court on 3/3/2025. A copy of the instant petition be also furnished to Ms. B. Bhuya, the Ms. who is assisting you, Ms. So-and-so, who assists Ms. B. Bhuya, the learned standing counsel of the of the BTC, so that she would be in a position where I can't put your name. You cannot obtain instruction. Put her name. Put her instruction. So that she is in a position to obtain instructions as to whether the mandate of the learned full bench of the court in Tamser Ali have been adhered to. The name of so-and-so be shown in the cause list. Your name
Lordship,
cannot be shown.
yes.
Her name will show.
SC or no, not required. Lordship, a fixed date can be given.
Yes, I'm fixing it.
Right.
This matter on 1st of December for, not 1st of December, 24th of November for an update.
Three.
May I pray, Lordship? Lordship, this contempt petition is filed alleging violation of the order dated 9/4/25 passed in WBC 5961 of 23. The effective portion, your Lordship will find at page 33.
What is the direction?
The Lordship at page 33, Lordship. May I read, Lordship?
Oh, this one.
Yes, Lordship. Lordship has already issued a notice in the writ petition, that is the WBC 6139 of 25.
Why you making so many people a party?
Lordship,
How many people have you issued notice?
Lordship to all, except the respondent number. Lordship, we have made a statement as regards the respondent number 4. He has taken over charge from the earlier incumbent. That
No,
is-
have you issued notice
Yes,
to
yes,
these
Lordship.
people? Where?
Lordship will find that first notice which we have sent after the order passed by his honorable court
Hmm.
is at page number 30.
All these notices are to
Before-
the commissioner.
No, Lordship, page 34, Lordship. Lordship will
Page
fi-
38 is commissioner,
Lordship, page 34, Lordship will see. It has been,
commissioner.
no, Lordship, down
the
below,
commissioner.
Lordship, the received the signs. And in fact, Lordship, these people were present in the meeting in which the minute was again taken to re-verify the bills. Later, Lordship will find it page 47.
No, no. How do you say that the others have received?
Lordship, they are aware about the order. Lordship will find it at page 47.
Huh?
Lordship will find it at page 47.
So there.
So Lordship, we have communicated the notice based
are
on
not
which
going
again
to make
another
the
meeting
payment.
was held.
We are not going to make the payment.
Lordship, the direction is to all the respondents. Otherwise, actually, it should have been respondent number 1. But the direction is to all the respondents in the order.
Where?
Lordship,
But we have not communicated to all.
Lordship will communicate, Lordship.
No.
Lordship will find the seal down below, Lordship. It has been
No.
received. In one letter only, they have received.
No,
Yes, Lordship.
no case.
And Lordship, the awareness of the order is important, Lordship. Later, Lordship will find at page 47 in the minute, which is now in challenge in the writ petition.
The awareness, I may be aware, he may be aware, you thus may also be aware. But the question is whether he has the authority to make the payment.
No, no, that will be made on.
Why you are making the executive engineer party?
No, because Lordship, the decision which was taken subsequently to circumvent the order passed by the court, these people were a party in
That
that.
you have already challenged.
Yes, Lordship, but they were party to the meeting also, Lordship,
So what?
where the decision
They
was
have
taken.
been made a party out there, that is a different
So
thing.
Lordship will issue notice to the respondent number 1 at this stage, container
Yeah.
number 1, and
Only one,
at this stage, Lordship.
not others.
If required, Lordship will issue the notice to the other parties
No,
later on.
As of now, this court doesn't want speech.
As of now, Lordship only do 1.
This is an application filed alleging willful, deliberate violation to the order passed by this court dated 9/4/2025, passed in WPC numbers 5961/2023, as well as the order dated 16/5/2025 in IA Civil 1404/2025. Pusto. This for issue notice, making it returnable on 1st of December, I did I fix the other
24/11.
matter? The writ petition
On 24/11, Lordship.
on, you can serve it
Yes, Lordship.
on
can serve by Dusty also if
24/11/2025. Making issue notice only upon respondent number 1. 1 and 2.
Lordship.
Making it returnable on 24/11/2025. This court, for the present, is not inclined to issue notice upon the respondent number 2 to 6, 3 to 6, which shall be considered at a subsequent stage if so necessary.
Lordship.
Pusto. The respondents herein are directed to bring on record their stand by filing affidavits as to whether the order passed by this court dated 9/4/2025 in WPC number 5961/2023, as well as the order dated 16/5/2025 in IA Civil number 1404/2025 have been complied with or not.
Lordship. Lordship.
Item four,
I may be permitted to take step by Dusty also if required. I may be permitted to take step by Dusty
Uh,
also.
That's very dusty permitted.
Obliged.
Diverting them, huh? Yes,
My
what
lord.
are these?
My lord, order is, my lord, at page 13, my lord. The order has not been complied with, my lord.
What order?
Lordship is, direction was there at para 5, my lord.
Direction is given to whom?
Given to the respondents.
All your other matters are same.
Same.
Madam, take instructions. Why these amounts have not been paid?
Mano proper.
গোটেইকেইটা এটা মই কৈ দিছো বাকীকেইটা এনেকে হওক Third, Mr. J.L. Bhuiyan, the learned counsel, appearing on behalf of the petitioner, J.I. Baldwin. The instant application has been filed alleging willful and deliberate violation to the order passed by this court. Oh, wait, how is it violated?
My lord, I have approached to the authority.
No, all these receipts have been delivered on 10/9/2025. 3 months.
My lord, earlier also.
No, there's
Lordship
no earlier
kindly see-
business out there.
Lordship kindly see
No,
page
no.
15, my lord.
Earlier one, it is not received. Where's the receipt?
They never give my lord receipt.
So,
book.
you have issued it on 6/9.
My lord, that is the subsequent. First notice I have
First
given.
notice, where is it?
Page 15, my lord. I made
Page
in,
15, there is no receipt. No,
my lord, they never issue, my lord, acknowledge.
no, this is not ripened into a case. The court directed to make payment within 3 months.
My lord, I have
You-
approached to
These
the,
documents were received only on 10/9/2025.
my lord, this is the
Therefore,
subsequent. matter.
3 months will expire after 10/12/2025. Oh,
My lord,
premature.
first,
Premature.
my lord, first notice, lordship kindly have a look.
Premature.
Lordship
Premature.
kindly have a look, my lord.
Okay, we dismiss it on that.
No, my
term.
lord.
Premature, withdraw to file whenever it is necessary.
My lord, that may not be, my lord.
Withdraw
Lordship
with
fix
to
the matter
file.
after December.
Huh?
Lordship fix the matter.
Absolutely no. As of now, it is premature. Oh, my goodness. And all our cases are
No, my
same.
lord, other case, my lord,
Very,
আছে.
very, same.
Same.
সবতে লেখো।
Two notice I have given, man. Acknowledgement they never put seal, man.
So if they don't put, you also know you are Mr. J.I. Baldwin does so many police cases along with Mr. L. Mohan. They know this is not the first time it has happened.
Lot.
Therefore, it will happen. The present application,
May be given liberty to show.
oh, definitely.
Lordship.
The present heard Mr. J.I. Baldwin, the learned counsel appearing on behalf of the petitioner. The present application has been filed alleging willful and deliberate violation to the order passed by this court dated 23/9/2024 in WPC number 3574/2024. This court have duly perused the said order whereby directions were given to the respondent therein to make payment of an amount of rupees 376,688 within a period of 3 months from the date of receipt of the certified copy of the order. From the perusal of the materials on record, it is seen that the petitioner issued communication on 6/9/2025 and the same was received only on 10/9/2025 as would be apparent from the track consignment note report enclosed to the instant application. Full stop. In that view of the matter, it is the opinion of this court that the instant contempt application is premature and cannot therefore be acted upon. Accordingly, the instant contempt application stands closed. Liberty, however, is given to the petitioner to again approach in the circumstance. The order dated so and so, dated 10/9/82 order to stands dated 23/9/2024 in so and so remains uncomplied beyond the period after 3 months of receipt of the certified.
Other matter, my lord, amount will be changed and order will be changed.
Hello.
4 to 10, my lord.
Ah,
Lordship,
see? You should have been more
10
careful.
lawyer আছে 4, 5, 6, 7, 8 to 9. 9 or 10. Offline.
Item 8.
Yes, what is this? Who is appearing number 8? Ah. Non-payment,
Yes, your lordship,
what?
contractual bill.
This is which department?
Water resource,
Water resource.
yes.
Now, why should this court issue notice? Order passed in the month of February
92.
2024.
Yes.
They received on 22/2/2024. What is the limitation? Limitation?
Your lordship,
Limitation? Huh?
my seniors on legs if later. My seniors on legs, please, matter may be passed over for.
No, no, no. You
I
have to
have
help
no
me out. Tell me, how many years of practice?
Just one,
1 year.
not yet, one.
Huh? Okay. If your senior would have come, I would have dismissed it. I won't dismiss it in your hand. You should notice this is an application filed alleging willful and deliberate violation to the order dated 19/2/2024. Passed in WPC number 630/2023, whereby there was a direction upon the respondents to make payment to the petitioner. The outstanding admitted due within a period of 5 months from the date of receipt of the certified copy. No, madam, ask your senior to come. I'll dismiss it on his. Why haven't you issued notice to anybody else and making everybody a party? And you should have made these people a party, na? And issued to the commissioner and secretary government of Assam. You are asking the payment to be made. You have only issued notice to the executive engineer. Why haven't you let your senior come? Who is your senior?
Tinglum, Tinglum,
Huh?
Tinglum.
And Noor.
She's on legs, yeah.
Okay, ask her to come. I'll dismiss it in our hands. I can't issue even notice in this case.
Much obliged.
Item 11.
Yes, item 11, the council on behalf submits that a matter be listed again as Bora. Who is this Bora? Oh. What is the matter? Completion certificate given in the year 2023. Okay, we dismiss it here. No ground. Yes, what are we submitting? Anybody submitting finance, PHE? Anybody from PHE? Mr. Gogoi,
Yes, sir, Lordship.
these are matters of 2023. How is it possible? How will you verify? Huh?
Work orders of 2012.
12 and the completion certificate is 2024, 2013. How will you verify? There's not even a liability certificate. Oh, I think we should dismiss it. Don't you think so?
This is the Lordship.
You can't verify.
We can't verify because whether it is there or not.
Possible. Okay. Who is appearing? Anybody?
Yes,
Mr. S. Bora. Who is Mr. S. Bora? Before vacation, when it came, Who was appearing?
Mr. Esbora was appearing.
Oh, yes. Let me dismiss it in his hands. I was about to dismiss it. Anyways, I'm dismissing it only.
There is some delay, my lord. My
That's
lordship will
not
post-
some, not some. 12 years is not some.
lordship will post it any other day, my lord.
Huh?
Lordship will post it any other day, my lord.
Chalo, dismiss karo. Heard Mr. Esbora, the learned counsel appearing on behalf of the petitioner. Mr. R.R. Gogoi appears on behalf of the PHE department and Mr. A. So-and-so Soliha appears on behalf of the finance department. The petitioner herein has approached this court seeking a direction that the remaining outstanding amount of rupees 883,298 be paid to the, be directed, be paid in a, seeking the appropriate direction upon the respondents to the effect that that the remaining outstanding amount of rupees 883,298 be paid to the petitioner along with interest at the rate of 12% per annum. This court duly takes note of the materials on record wherein it is seen that the petitioner claims that he had been issued various work orders in sometime in the year 2012 and 13. It is also the statement of the petitioner that these works were completed and work completion certificates were also issued as enclosed as Annexure 2 to the writ petition, 2 series to the writ petition. However, the said amount having not been paid, the petitioner has approached this court. There is not a single explanation why the petitioner has approached this court after a decade, seeking the said dues. There is also nothing on record to show that the respondents have at all acknowledged that the said payment was, that the petitioner was entitled to such payment. In this regard, this court have also taken the submission of Mr. R.R. Gogoi, the learned counsel appearing on behalf of the PHE department, who submits that when a petitioner approaches this court seeking a writ for making payment upon due verification, after a long period, it becomes difficult. It becomes difficult on the part of the respondents to carry out any verifications, and thereby the respondent loses a valuable right of defense. তাৰপিছত এইখিনি আছে কৰি dismiss আৰু be that as it may, liberty given to civil court.
Item 14.
Yes, Mr. NNB Chaudhary, where is he? Who is appearing? You are appearing, yes.
Your lordship, my lord, lordship.
Huh?
My senior is on legs in court number 1, lordship.
Court
Ma'am.
number 1, what is the admitted dues?
Admitted dues amount is 3,52,990.
Work order 2020, okay, notice issue. This was in Namdi.
Kalyani De, lordship.
Eh?
My name is Kalyani De.
Okay.
Manoj.
They are on 9th of February.
Lordship, I am appearing only for respondent number 1 and 3.
Who is appearing for all? Who are the people?
Lordship, the others are the seat corporation.
Huh?
Assam Seat Corporation.
Assam?
Seat Corporation.
Payment to be made by?
Lordship, I am 1, 3, 6,
Agriculture, you are appearing 1 and 3.
1, 3, 6, and 7.
And 2 is this. And this, Mr. Samaria, and you are appearing for 6 also?
Yes.
6, 7?
6 and 7.
And Mr. Samaria is for 4 and 5? He's the standing counsel?
Yeah.
Give a copy to him. Mr. So-and-so. Notice issued returnable on 9th of February 2025-26. Affidavits be filed on or before 22nd of January 2025. Liberty given to the petitioner to file reply. Yes, Mr. Kayam.
The matter regarding bifurcation of a fishery, government fishery.
What?
Malad,
To pass an appropriate order for bifurcation and or division in between the administrative control of Iman. My goodness, does this court have such powers?
because the authority can initiate the process,
Tender and settle so and so and so and so within stipulated period. Additional secretary to consider and dispose of the representation.
Since we have filed a representation that the
Who are
government,
you?
we are the fishery, cooperative society.
So,
Since we are a small fishery society, we cannot compete with the big society.
they have a particular fishery.
Yes,
You want the bifurcation.
bifurcation.
Can this court pass such order?
Because since we being the fishery cooperative society, we are fishery less since long time. Because we cannot compete with other society. And the present,
No, because you can't compete.
Malad.
Can this court direct? I'm asking you because whether how a fishery is to be managed is absolutely within the domain of the government.
yes,
Why on earth this court should issue a direction upon them that you kindly bifurcate so that the petitioner, Mr. Kayam's client can be helped?
since in this regard, I have filed a representation before the authority, and
So can this court give the direction upon them to consider a representation which otherwise has no value?
the government can because
Government can do many things, but
but
the government can also have a hunger strike.
That is
So
a
who-
personal problem. In
who-
the representation, they have said they are facing financial hardship. So that's why that fisheries should be bifurcated.
without,
58 lot,
Yes.
53 lot.
without initiation, how
They
the-
have been getting this type of cases only whole day
Mm.
till from 11 to 12.
without initiation of the process, how the
Mr. Counsel, absolutely no. This time, first of all, show me when there is a requirement of a bifurcation. It is absolutely within the wisdom of the government
Yes,
whether
sir.
to bifurcate or not.
yes,
And if they don't do the bifurcation, then obviously you may have some right. But you have to see, show me a statutory provision which shows that they are required to bifurcate.
So-
Then only I can, you
Yes.
see, you are asking for a writ of mandamus. Means they have a corresponding duty as per the act.
Yeah.
Show me that.
but I have gone through the rules, there is no provision.
Ah,
Yeah,
then
But
on
Malad-
what basis? Because Mr. Kayam wants.
but
So tell me,
since
this type of cases won't help.
Malad,
you.
since I have filed a representation before the
Your
authority, they can-
representation, you will tomorrow say to these people, kindly give me the moon, and then you come before this court and say that, oh, see, the fisheries department is not giving me the moon. And should I then pass an order? Then look, kindly consider the representation. They will laugh at the court.
without initiation of any process, the government cannot. Because how the government to initiate the
No,
process?
you have to show me that these are the circumstances when there can be a bifurcation.
This
Show me that.
this fishery is exactly in between the two districts. The report is shown in paragraph 5, page 41. And more than 50% of the fishery is fall within the district of Dhubri. And we are belongs to Dhubri. But the settlement has been made by the Deputy Commissioner South Salman Mankasa since long. But we cannot participate since we are a small fishery and we cannot complete the other fishery.
So you challenge the term of the condition of the tender, saying that you are not being participating because this is one fishery where partly it falls in Dhubri and partly it falls in Mankas, this Mankas.
For the time being, your lordship may kindly to page tab 41. It is a joint report of the circle officer.
Understood. So whenever you are not permitted to do it, then you say the term, because half of it falls here. So we are being stopped. So my right under 19(1)(g) has been taken away.
Yes.
Can this court therefore direct, as of now when tender has not been issued?
Since
Dismiss, withdraw, which one?
Yes, my lord, I would do liberty.
Withdraw, withdraw. You come when those type of tenders are issued, and thereby you are affected.
I have to silence the.
Mr. D. Akaim, the learned counsel, heard Mr. D. Akaim, the learned counsel appearing on behalf of the petitioner. Mr. S.R. Borua appears on behalf of the government of Assam, the district administration. And Ms. S. Sutia appears on behalf of the fishery department of the government of Assam. Mr. D. Akaim submits that on account of the particular fishery being number 3/89, Ongamore, Jingiram Part 1 and Part 2 fishery falling within the administrative control of the district commissioners Dhubri and South Salmara Mankasa. The petitioners who belong to the Dhubri district are being not permitted, and as such, the present writ petition has been filed. This court inquired with the learned counsel appearing. He, however, submits that taking into account that if when situation arises, thereby the petitioners are not permitted to participate in such settlement process, the petitioner would be well advised to again to challenge such tender process. He therefore submits that the petitioner would not like to proceed to the instant writ petition. Taking into account the above, the writ petition stands closed on withdrawal. However, liberty to the petitioner is given. In the circumstance, their rights under Article 19(1)(g) is being affected.
Obliged.
16.
What it is,
Lordship, item 15 is the liability statement, Lordship. Page 15. It's a admitted amount, Lordship, and it's a covered judgment. Covered case.
go before civil court. 2013, 14, 15.
Lordship, liability statement is issued.
Why should this court issue notice?
Lordship. Lordship.
What?
Will file a Lordship.
I am trying to dismiss his petition. You want a notice?
Lordship.
Go before civil court.
Lordship.
You got the liability statement, file a
Lordship.
summary sheet, go there. I'm not going to do this one.
Similar matter.
First of all, why you got the work order in the year 2012? There's only one work order enclosed here. You are asking the payment for 3 work orders. Why?
Lordship, liability statement, there's 3 work order, Lordship.
So now you want that money,
Lordship.
which is being given in the year when?
2012, Lordship.
Liability statement given when?
2023, Lordship.
2023.
Yeah,
There is no date also.
Lordship, in page 22, page 13 is the RTI reply, Lordship. This is a part of the RTI
Go
reply.
there. I'm not going to entertain this type of. 2020, it's okay. 2013, 14, you have enclosed only 1 work order. No, it's
Lordship,
okay.
RTI. Lordship, similar matter already disposed of, Lordship. I have
Where?
the second. Similar matter already disposed of, Lordship. It's a
By this
covered.
court?
Yes, Lordship. Yeah. Covered judgment.
What is the period of the work? Not mentioned in this order.
Lordship, those matters.
Won't help it. Sorry. What were you doing all the while?
Lordship, they appeared before the authority and they were promising like they are going to pay next year.
Where's your statement?
Lordship, it's,
That you have
they
appeared
appeared
to
and
the authority.
filed
When
for
did
the
you appear?
RTI. They filed the RTI, Lordship.
Huh?
RTI reply was issued on 22/5/2023, Lordship. That is page 13.
No, page 13 is you have woken up in 2023. And then after that, you have come after 2 years before this court. Why should this court entertain this type of petition?
Lordship, it's a small amount, Lordship.
That is why these small amounts are the most. Doesn't small a drop of water become an ocean?
Lordship, may kindly consider, Lordship, it's a covered,
Dismiss.
Lordship, it's a
Okay.
covered case, Lordship.
Not our case.
Similar matter already.
You have got this document, go there before the civil court, file a summary suit. You will get the everything. Fine, fine. And how will this pertaining to the central government will have anything to do with this?
Lordship, the amount payable is, like what, in this order, it's reflect of the.
No, that case is different. But here the case is different.
It's the same case.
No
Lordship.
case thing. How are you saying that the central government it is under the central government?
So
power?
water resource, they submitted. the
Water resource
80
may have many things. Are you saying anywhere that it is a central government fund?
So in the recent judgment, it was said, Lordship, they appeared and they
That case. Hello.
appeared water resource.
Okay, we dismiss it. Heard Ms.
Lordship,
Swain.
can you issue notice at the stage?
No,
Lordship?
no. That I'm not doing. I have so many matters that they dismissed. People will say what has happened with this case. I've already dismissed how many matters? 2 matters like this.
Lordship, may kindly consider one.
No. Issue notice enough. Heard Ms. Swenso, the learned counsel appearing on behalf of the petitioner. You are appearing? Swenso appears on behalf of the respondent. Number 1. Ms. Swenso appears on behalf of the respondent number 1 and 2. You appear for 1 and 2. Swenso appears on behalf of the respondent number 2, 3, 4, and 5, 6, and 7. The petitioner herein has approached this court seeking a direction that an amount of rupees 1,16,504 be paid to the petitioner by the respondents. This court duly takes note of that the claim so made by the petitioner is in respect to certain work orders of the year 2012 and the bills were duly submitted in the year 2013, 14, and 16. Thereupon, it is the further claim of the petitioner that certain amount have been paid to the petitioner in respect to certain amounts have been paid. However, an amount of rupees 1,65,000 and 16,504 remains outstanding. It is under such circumstances, the present petition has been filed after obtaining information in the year on 22/5 have been filed. The instant requisition has been filed on 17/10/2025 after obtaining an information under the Right to Information Act on 22/5/2025. Public. Who wants to say? Very difficult. You. Difficult. Dismissed. Liberty given to go to a
17.
Wait, please, Your Honor.
Please.
as per the e-tender, as per my lord, page 19, this annexure 2, in total 6 districts, the petitioner has, my lord, supplied all these hybrid maize seeds. And in the year 2021, and my lord, page 20 is the 2021 is the, my lord, the party has received these seeds, my lord, with their signature, my lord. Now, in the year 2000, my lord, 21 at page 33 and 34. 34 at serial number 17, they have paid only about 50%, 20 lakhs. They
Where?
are at, in 21, my lord, 2020, at page, my lord, 33.
What is your name?
Hybrid, here, my lord, it is.
Rashi seeds.
Yes,
Where is the Rashi seed business? These were all Rashi seed?
Rasi seeds. No, my lord, these are all other company, my lord.
Which is yours?
Yes, at serial number 17. Out of total 41.56000, they have received, this petitioner has received 20 lakhs. So balance amount, now Lordship may kindly turn to page 36. After submitting of various my lord representations on 28/3/24 to the managing director of this corporation, my lord, here they have given this notes, my lord, payments.
Have you served the copy upon Mr. Samaria?
Samaria, my lord.
The standing council, isn't it? Six council of here. Why you are not serving?
This is for agriculture, my lord.
I know, but you are asking the money from Seeds Corporation,
Seeds
are you not?
corporation.
And why haven't you made the Seeds Corporation a party?
Because they will have to pay this.
Why have you not made the Seed Corporation a party?
They are party, my lord.
Where?
The general manager, Assam Seed Corporation.
Managing director, then tomorrow don't make the state of Assam also a party?
Because the
Make
agriculture
the commissioner
department,
and secretary of the department as a party?
agriculture department, my lord. That's why, because they receive from the agriculture
Payment is to be, who has passed the order?
Seed Corporation, my lord.
You have written the letter on 28/3/2024 to whom?
Seed Corporation.
Then why Seeds Corporation is not a party?
My lord, by mistake, my lord, the general manager is party, but, yes. The corporation should have been,
Permissible, madam?
I may be allowed to add this party, my lord. Extra copy I will serve.
Because tomorrow what will happen? I pass a direction to the managing director to make the payment.
Yes,
That is only first,
Yes, yes.
it is only here, but you are not asking the company, the
Yes,
corporation to make the
corporation.
payment.
The
Is
main
it
party.
so?
Main party. He may be represented by managing director also,
Ah,
but
you could very well say the Assam Seeds Corporation Limited represented by so.
yes. So I may be allowed to, my lord, correct this.
I'll make that correction with it. Issue notice making it returnable on 2nd of February 2026. About Mr. Arusami, the learned counsel appearing on behalf of the petitioner at the outset say submitted that manner in which the respondent number 4 has been described appears to be not correct. He therefore submits that the respondent number 4 ought to have been described as Assam Seeds Corporation Limited, represented by its managing director, having its office at, what is the office?
This is, my lord, at Khanapara.
Who is going to write?
Khanapara, Guwahati 22. I'll write, my lord.
You'll write. Mr. This is not done. However, why have you filed this petition in this manner? Copied and pasted from the earlier order, na?
Yes. It's back, my lord.
At Anapara. Guwahati 781022.
22.
He therefore submits that he may be permitted to make this necessary change in the description of the respondent number 4. The petitioner is accordingly given the liberty, directed to make, given the liberty to do so. And the petitioner as such would be filing a fresh memo of parties and taking into account the said submission. This 4 changes the description of the respondent number 4 as the Assam Seeds Corporation Limited, represented by its managing director, having its office at Anapara, Guwahati 781022. So the petitioner is directed to file a fresh memo of parties by Monday, and on the basis of that, the registry shall, on the basis of the present order as well as the fresh memo of parties, the registry shall make necessary correction in the first title as well as update in the CIS. The case of the petitioner herein, issue notice upon the respondent number, issue notice returnable on 2nd of month. Issue notice returnable on 2nd of February 2026. The case of the petitioner herein is that the petitioner supplied hybrid seeds of an amount of rupees 41,56,000 hybrid maize seeds. And out of the said amount, an amount of rupees 20 lakhs was paid in the year 2022. Thereupon, the petitioner have been insisting the respondents, more particularly the respondent number 4 and 5, to make the payment. However, no such payment has been made, and it is under such circumstances the present petition has been filed. The respondents are directed to bring on record their stand by filing the affidavits on or before 22nd of January 2026. Issue notice to the Ms. So-and-so accepts notice on behalf of respondent number 1,
3 and 6.
1, 3, and 6. As regards Mr. H. Solia accepts notice for respondent number 2. Extra copies of the resolution be furnished by Monday. As regards the respondent number 4 and 5, steps be taken by speed post. So in addition to that, the petitioner is given the liberty to take steps by way of dusty routed to the registry of this court and file an affidavit of service on it.
18.
May it please your lordship.
What is the matter about?
Lordship, the matter, I have prepared a list of dates if I may be allowed to submit it. Your lordship, in brief, the facts of the matter is that the petitioner, it's a registered MSME unit. And your lordship, I had supplied some materials to the respondent number 4, and pursuant to that, there is some dispute, and there is a pending amount of 64 lakh. Your lordship, what has happened after that, I had filed an application with the MSME Facilitation Council, but as per the mandate, it should have been resolved within a period of 180 days. But even after a lapse of more than 2.5 years, it has not been resolved.
By the MSME?
MSME Facilitation Council. Yeah, your
Under
lordship, as
18?
per the section 18 of the micro, small and
So
medium,
as per 18, there was a reference made.
I filed an application with the Facilitation Council. So after that, as per the mandate of section 18, if I may read the section 18 of the act,
What is required? Now, I know
Yes.
what is there, but what has happened thereafter?
thereafter, they have not responded to my applications or
You filed
requests.
the application when?
19th of November 2022.
So it should go for arbitration.
Not right now, yeah, what the act says is that if the mediation fails, then it may be referred to
But
arbitration.
this is amendment of 2023,
Yes, your lordship.
thereby bringing in the Mediation Act of 2023.
23.
Okay, they have not done that also.
No,
No mediation.
no, I have applied, but only a date had been given. That is the 16th of February 2024, but they did not appear, and pursuant to that, I have repeatedly approached them, but they have not replied or reverted back.
So this facilitation center is in Guwahati,
Yes, it is in Guwahati.
and you have to get the money from whom?
Respondent number 4, that is managing the Simplex Infrastructure Private Limited.
My lord, before going, this copy is not been served to us in HIDCL because he is telling that we have to pay. In that case, I have just now written lot of function like second copy.
You have not served upon NHIDCL?
Should I?
And what is this, Mr. Counsel? Why you are making managing director National Highway?
Your
Don't you
Lordship,
think that
because-
authority is to be made a party?
Your lordship, the respondent number 5 is the principal because the work was allotted. to the-
Understood, but don't you think the National Highway and Infrastructure Development Corporation should have been made a party?
They are making party.
Number
Why
5.
you are making the managing director a party? He may represent. But
Through
isn't
the-
that an authority? It is like a National Highway Authority of India.
National- That is,
Then why you are doing it in this manner? Similarly, Simplex. Why you are making the managing director a party? You have a claim against Simplex.
yes, your lord.
Why you are making the managing director a party?
So
It may be represented by the managing director.
So actually what has happened, lordship, counsel from Kolkata had approached regarding this matter. So I'm happy, I did not draft it, so he asked me to appear on his behalf. But my mistake, because I'm representing now, it's on, I totally accept it. Your lordship, if a opportunity may be given, I can amend the counsel.
You do one thing,
Yes, your lord.
you file an amended cost title and then let the matter come up.
Yes, your lordship.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the respondent number 4 and 5 have not been properly described in as much as the respondent number 4 ought to have been described as Simplex Infrastructure Limited Service. What is this? Can't be Simplex Limited. What you have written, this is not done, Mr.
Yes, your lord.
What is this? Kindly, it is Simplex Infrastructures Limited. You have to mention it is a company registered. Where is that mentioned? Very sorry state of affairs. File it properly. Withdraw and file it properly.
Right property.
Mr. So-and-so, the learned counsel submits that there has been certain defects in the mentioning of the names in arraying the parties in the manner in which the parties have been arrayed. And he therefore submits that being a formal defect, he may be permitted to withdraw the instant writ petition and to refile. Taking into account the above, the instant writ petition therefore stands closed on withdrawal. Liberty, however, is given to the petitioner to refile by making necessary correction in respect to the by carrying out the necessary rectification of the formal defects.
So, 19,
Mr. C. Bolwa appears on behalf of the NHRDC. Mr. C. Bolwa,
My lord.
yesterday there was one
Yes, my
matter.
lord. Yes,
Ah,
Today
yes.
they are.
Because they have not served it.
Yes, I'll be appearing, my lord.
Ah, very good. I put your name out there. Yes, Mr. H. Das, what is this?
Well,
NOC permission
Jointly, my
not
lord,
given.
NOC received,
Huh?
jointly permission received, my lord, page 47. Separately, my lord, intending purchaser, my lord, wanted separate, my lord, sale permission. That's why we applied for, but circular officer is not giving me, my lord. Page
What happened?
47. Page 47, my lord. Annexure 7,
So one permission is being given.
given, my lord,
And-
jointly. But we applied for, my lord, joint, separately, my lord, but that has not been, in spite of the Mondal has submitted report, field verification was done in the month of February, my 25.
How much land you are purchasing?
One kata, my lord.
You are purchasing one kata.
Yes, we're selling, my lord. One kata, I'm selling, my lord.
So
To the-
with this permission, you cannot transfer, execute two sale leads.
No, my lord,
Huh?
not.
Not yet.
With this, you can't execute two sale leads.
So, he is that petitioner is intending to sell the plot of land to two purchasers.
That I understand, that's
Yes,
why I'm
but
saying,
they
with this permission, can he sell to two persons by two sale leads?
No.
Perhaps then it cannot be that.
If there were separate applications filed, why you have given one application? One permission?
Initially jointly applied for.
How?
Initially jointly applied for, but intending purchaser, my lord, wanted separately sale permission. That's why we tried to obtain that sale permission we applied for, but the circle officer is not giving us because he is the main person, my lord. Otherwise, deputy commissioner and the Mondal also submitted report, my lord.
So
Metro
Did you get
Kamrup,
did you get an,
page
but
47.
this permission has already become invalid.
Now it is invalid.
So you apply for a fresh one.
Yes, my lord.
Separately.
Yes. We have,
Have you applied separately?
yes, my lord.
Then what happened?
But they are not giving us this permission, my lord.
Why?
Circle officer is not giving, my lord.
And what are
Not
these
now.
sale leads for? There are certain sale leads you have enclosed.
Earlier sale leave,
Now where is your fresh application?
fresh application starts from, my lord, page 49. Annexure 8, page 49. And my lord, also, my lord, page 91. All everything clear, my lord.
Hmm?
All everything clear. NEC, everything, my lord.
But
APD
isn't it the mandate that the circle officer has to give reasons
Yes.
within a particular
He
month?
cannot hold it like that. Because he has to forward it to the office of the district commissioner.
Yes.
And from the office of the district commissioner, that NOC will be given to them.
So the permission has to be given by the additional district commissioner.
Yes, yes, yes. But it
Isn't
has
it?
to be come from the concerned cycle officer.
So
Circle.
circle officer is not forwarding.
Yes, my lord, not forward.
That is your allegation.
It is my, yes.
Where is that allegation?
Hmm? Paragraph 8, my lord. Page 8, paragraph 8. Nine dot application.
So your grievance is only the circle officer not forward.
Yes,
Then why you are making the relief one?
because my lord, main authority is the deputy commissioner.
Oh.
He has given already us the permission, but as papers, when they are to submit the papers, field verification also done in the month of, my lord, February 2025. But it is kept pending, my lord. So without, so at
Your
least
allegation is only against the circle.
circle officer, my lord. He is showing different causes.
So if the circle officer sends, it is okay with you. You don't have any further cause of action.
No, my lord, because, my lord,
He is having twofold prayer.
yes, my lord.
One is
No, because you are saying that the circle officer is doing some mischief.
Hmm.
We have no allegation against the district commissioner.
Yes, that is there. Overall, it is there, my lord, because he is just absolute authority, my lord. But in spite of Mondal has submitted the report, my lord, in the month of February, he is not giving us, my lord. We have
Anyways,
come
whatever
to-
may be,
Hmm.
Section 21A.
21.
Categorically mentions that if you don't give the year within 1 month or 2 months, whatever it may be, you have to inform him why you are not giving. And where is the information? Has he provided
No,
any
no, no,
information
nothing.
verbally?
Verbally.
1 week.
Lordship.
We have it. 1 week.
Yes, my lord.
Issue notice making it returnable on Adhikari. 7. On 17th of November 2025. Mr. S.R. Burua accepts Mr. S. Dutta accepts notice on behalf of the respondent number 1 and 2. Mr. S.R. Burua accepts notice on behalf of the respondent number 3 and 4. Extra copies of the writ petition be furnished to them during the course of the day. The petitioner herein is a owner of a plot of land at measuring 2 Katha 10 lechas, isn't it?
Yes, my lord.
Covered by Dag number 70 of KP Patta number 6, situated at village Bilpusi under Beltola Moza, Beltola Mauza in the district of Kamrup, Petro, Assam. The petitioner had entered into an agreement with one Binapane Hazarika and one
Bonita Deck.
Bonita Deka for sale of 1 Katha land each. So initially, the petitioner applied for a permission. Initially, the petitioner applied for a joint permission. Dated 30/5/2024 for sale of the 1 Katha each to the said Binapani Hazarika and Bonita Deka by an application dated 30/5/2024. The said permission was granted on 15/7/2024. However, subsequently, the intending purchaser wanted separate deeds of sale, and as such, the petitioner again filed separate applications seeking permission from the respondent number 3. It is the allegation of the petitioner that the respondent number 4, for reasons best known, is not acting on the said application. And as such, the petitioner has approached this court, is compelled to approach this court seeking appropriate redirection. Mr. S.R. Burua, appearing on behalf of the respondents number 3 and 4, shall apprise this court why the respondent number 4 have not processed the application of the petitioner so that the same can be placed before the respondent number 3 for due approval of the permission sought for. They said instructions be placed positively on the next date so fixed.
20. Maybe.
Yes.
Only mention was made, my lord.
What is the matter about non-payment?
Non-payment.
The work orders have been, the 2017 work order.
Hey, dismiss. I will give you 2005 or. These are all 2005 work order. are you saying 17? These are all work orders of 2005.
Yes.
See the bills dated 16/8/2005, 8/1/2003, 11/6/2003, 39/92, 33/94, 17/4/94, 18/3/96, 23/97, 17/4/95. My goodness.
The representation has been made in the year 25.
And dismiss it. Dismiss karo.
21.
Yeah, naam to do dismiss. Yes, who is appearing for the other side?
Please, your lordship.
Devoter.
Devoted lordship against the name of the father of the,
Since when you are a devoter?
your lordship, not me, your lordship, my father. My father, your lordship.
Is a devoter.
Devoted, your lordship. Subsequently, he died, your lordship, in the year 2015, your lordship. But I have a doubt, your lordship, there might be a reference, your lordship, against the father of the petitioner, your lordship.
How can there be a reference against the dead person?
No, it was the earlier, your lordship. Maybe it was.
Are you a devoter?
2013, your lordship, against.
Petitioner is not a devoter.
So if you are not a
I'm not
devoter, if
devoter.
your father was a devoter,
Devoter.
it was only doubtful.
Lordship.
Meaning thereby your father could not have voted. That's it.
Lordship.
Otherwise, the right that he is a citizen is there till it has been adjudicated upon.
Lordship.
But your father cannot vote now, as he is dead.
That.
So what remains? How do I decide this? Like direct, because there cannot be a reference against the dead person.
Yes, your
And
lordship.
again, because the proceedings has to be against the proceeding. The proceeding is the person concerned who has been alleged to be a person coming within the ambit from a specified location under section 6.
Lordship.
Isn't it? Then, okay.
No, otherwise, your lordship, because.
When you become a devoter, you come. Otherwise, as of now, you see, he has not been, I would have understood. If your father has been declared to be a foreigner, it is a different thing. Then you can come very well and say that he may have been he had died, but then also he's not a foreigner. So there would be a fallout upon you. But
Yes.
devoter is doubtful.
Doubtful.
So as of now, there it doesn't appear.
Yes,
And you are not a devoter.
no, I'm not a devoted, your lordship. For that reason, I have.
Make that observation.
Lordship.
Miss So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. Ali, the learned counsel appears on behalf of the Election Commission of India, and Mr. G. Pegu, J. Payang appears on behalf of the Foreigners Tribunal. And Home Department as well as the Foreigners Tribunal. Who appears for NRC?
NRC item.
You appear? Yes. Okay, Mr. So-and-so also for NRC, Namgute Didibo, Gita respondent. The petitioner has approached this court being agreed by the continuation of the name of his father as a devoter in the list, in the voters list since 2013. Because it is an admitted case that the petitioner's father had expired on
15, your lordship. 33 is the case.
12/4/2015. 12/4/2015.
12/4/2015. Under such circumstances, the question of proceeding against a dead person is not envisaged in any foreigners tribunal. This court inquired with the learned counsel appearing on behalf of the petitioner as to whether the petitioner is a devoter. The learned counsel submits that the petitioner is not a devoter. Considering the above, this court therefore is of the opinion that no directions can be passed in the petition as has been sought for. However, this court would find, accordingly, the petition stands closed. Before parting with the record, this court, however, observes That merely because the father of the petitioner has been marked as a devoter in the voters list of 2013, the same shall not prejudice the petitioner, who is the son, unless the petitioner, without following the procedure established under law.
Much such. 22.
Make the lordship. So this is also regarding devoter lordship. It's a devoter matter lordship.
Dead,
No. He has a mark D in the year 2005 lordship. 2005 or not.
same judgment,
I have
will
marked.
disposed.
Obviously.
Same.
My lord. 17 work order, my lord. It's 2017 work order, page 9, my lord. I have given representation also, my lord, page 28. 5 copy 26, my lord.
How much you entitled?
6,75,996, my lord. Total 8 works order there,
Where have you asked for?
my lord.
Where have you asked for? See your representation of Annexure 2.
Yes,
Clear
sir.
for immediate release.
My lord.
I have the honor to request you to kindly release payment for the following works as I have been facing so and so. 1, 2, 3, 4, 5, 6, 7, 8.
8 work order.
In this regard, all works is hereby enclosed herein for favor of your reference,
My lord.
as stated above. How much? You have not got a single penny. Then another requisition, another representation. With due respect, I take to state that I had entrusted the work of construction of 1,000 liters so and so issue. I had successfully completed the effort and handed over the work as per Annexure B of the work order. The bills for the aforesaid were submitted in due time, but I have not received the bill amount. How much?
6,75,000.
Are you saying for 8 works, it is 6,75,000? Let us see.
Yes, my lord. Page 9, first work order, my lord, 3,34,000. Thereafter, page 12, my lord, 48,000 something, 7,731. Page 14,
Where's the work completion certificate?
within the period, my lord.
Work completion certificate?
My lord, work completion service is not there. my lord.
Yeah?
Not there, my lord.
How can this happen like this? You have not, why should this court? First of all, 2017 work has been given. You approach this, you file representation in 2025 in the month of September.
That is my
And
representation.
immediately file a requisition.
My representation may be disposed of, my lord.
What? Go there, they will dispose it of, otherwise file suit. This type of cases can't happen. No work completion certificate, nothing. No. So and so appears on behalf of the petitioner. Mr. I. Bottakore appears on behalf of the respondent numbers 1, 2, and 3. Mr. A. Solia appears for the respondent number 4. The petitioner claims that the petitioner has filed the instant writ petition seeking a direction that the respondent number 2, respondent authority, more particularly the respondent number 2, should make payment of an amount of rupees 675,996 on the basis that the petitioner has completed various works have completed 8 works in terms with 8 different work orders issued on the same date, that is on 24/2/2017. Full stop. There is nothing on record that the petitioner has completed those works or that the respondent have acknowledged any amount which is payable to the petitioner. The record further reveals that on 9/9/2025, the petitioner only intimated submitted a representation to the executive engineer PHE stating that he needs immediate release of the payment, and subsequent thereto had issued another communication on 15/9/2025 seeking seeking release of the payment. And it is under such circumstances, as no release of the payment have been made, it is under such circumstances the petitioner has approached this court. Dismissed. Liberty given, he will.
Supplementary motion item 53 and 54.
After end of motion matters, though. At the end of the motion matter will be taken.
How many motions are there?
53 to 59, your lord.
Okay, hello, at the end of the motion. You wanted an upgrade. We have it at the last item of the day.
No, sir, motion matter.
Last item of the day. It
No,
can't be like this. No, we'll have it whenever
Sir,
it's
Lord,
there.
we did
We'll
not
have it
pray-
at 2. No, sorry.
We did not pray for an upgrade today, your lord.
We'll have it at the last item of the day.
At two lordship then.
Okay, 2,
Lord.
not before that.
Lord.
Not even 2. If there are some matters in 2, then after those 2. Next. Ah, yes. NHIDCL. What is the instruction? Why you have given somebody, made a person who has been disqualified out here? Why have you made them L1?
See, that is there after beginning, I got it and I'm coming then. Now it is under scrutiny. Whatever been expected, I'm submitting a bar today, scrutiny, whether it will be not in finalized.
Okay.
We'll-
No, it's okay.
Next week.
Very well. We have it next week. You should notice next week, but don't finalize without the leave of the.
That will not be when I'm taking responsibility.
No, no.
My courts are, I'm submitting a bar, we learned it.
No, you are saying this because otherwise it will become infructuous. You give it to somebody, he has to file another writ petition.
No, definitely.
Why do we want to load the writ petition so much?
No,
in this court?
definitely.
Even in the tender document, my lord, 1.4 clause.
No,
There
it's
is a
okay.
specific assertion,
Mr.
madam.
Bhattacharya, I understand.
Madam.
Did you say anything
Oh, madam.
without you saying I made the inquiry?
Yes,
with-
sir.
It is under scrutiny, I'm not going to finalize it.
Don't finalize without the leave of the court
Fine.
till the next date
Yes,
and give us an update as to what you have done.
next week, or 7 days, or 10 days.
Kamakhya Travels, you can serve it during the course of the, why you are making the government market?
Well, look, because the entire process was conducted through e-marketing process.
It is
So now-
okay, but you say
Madam,
they
what-
are to be represented by the National Highway Authority Infrastructure only.
My lord,
But you cannot serve them, na? How can you serve
no, there
them?
is a standing council also, my lord.
Government e-market?
Yes, yes, my lord. Yes.
Who?
To me, my lord, it's Mr. B. Chakraborty, he's handling these sort of matters. Because,
The standing council?
my lord, I need to check possibly because he's.
The moment you are saying standing
My lord,
council,
he's
then how
appearing-
can I take up the matter without him being
No, my
present?
lord, he's appearing in this matter, I mean, in such matters where the
He
gem is,
may be appearing for jail.
But-
It's a different thing.
that I correct.
But it cannot be a
That is correct.
standing out. That is a difference.
Madam,
I'm saying.
Now, I made a party, my lord, because my assertion is that one document was deleted where the respondent number 4 was disqualified. That particular document was deleted, and that's why, my lord, to retrieve that document, my lord, we don't have any expertise. Only the GM can do it. Now, if the question comes up, my lord, to that extent, my lord, only GM can help.
Okay.
Only because of that.
Should notice making it returnable on 17th of November 2025. Union, who is appearing? None appears on behalf of the Union of India when the matter is taken. Oh, yes, Mr. Gupta. Mr. H. Gupta accepts notice on behalf of the respondent number one. Mr. C. Borwa accepts notice on behalf of the respondent number two.
When NSA is there, instruction is there for Union of India can take it.
Huh?
One and two I can take it.
For?
1 and 2. The Union also I can take. Already our instruction is there. But yeah, he is a bit.
Let him do. One and he appears for two. Extra copies of the writ petition be furnished to him, to the council during the course of the day. As regards the respondent number 3 and 4, the petitioner is directed to take steps by speed post during the course of the day. And further, the petitioner is also directed to effect service upon the respondent number 4 by way of dusty routed to the registry of this court and file an affidavit of service on or before the next day. The case of the petitioner herein is that the respondent number 2 had issued a notice inviting tender through the respondent number 3 for providing and supplying of commercial vehicles on monthly basis. The petitioner participated along with various other bidders. Mr. S.P. Bhattacharjee, appearing on behalf of the respondent, petitioner submitted that out of the various bidders, that is 13 who participated, only only 2 bidders were held to be qualified. All the other bidders were disqualified in the technical bid. However, while opening the price bid, the bid of the respondent number 4 was open, and there is a move on the part of the respondent authority to allocate the tender to the respondent number 4, who is the L1 bidder. He therefore submits that the learned counsel therefore submits that when a bidder has already been technically disqualified in a 2-bid system, the question of opening of the price bid does not arise. The learned counsel further submits the reason. It appears that the reason must have been that the respondent authority wants to settle the contract in favor of the respondent number 4, which is contrary to the terms of the notice inviting tender. Mr. C. Borwa, appearing on behalf of the respondent number 2, submitted that the tender is still under consideration and has not yet been finalized.
Yes.
Taking into account the above, this court is of the opinion that till the next date, some interim protection is required. Otherwise, it may lead to multiplicity of proceeding and creation of third-party rights. Accordingly, till the next date, the respondent authorities may proceed with the tender process, but shall not finalize the tender without the leave of this court.
56.
Well, should I make it on 19th?
Yes.
19th or 17th?
19.
19th. The 19th.
Okay. Obliged to.
Yes, what is this?
In this case, my lord, the petitioner participated in bidding process, my lord, along with 16 others for settlement of a
Settlement of?
Moinabari Pub Bazar to Palm Moinabari Pargat for financial year 25 to 26, my lord. Here, my lord, total 5 of the bidders qualified for the financial bid, including the present petitioner, my lord. And there, everyone quoted, my lord, same bidding price. Despite this, my lord, as per NIT, my lord, it ought to have been, the settlement should be via lottery basis. But there was no lottery, my lord, and the private respondent was given settlement, my lord, without conducting any lottery.
Where is the order of giving?
My lord, settlement order is page 26, my lord.
Page
26, my lord.
Madam, we bid value of
34,650, my lord. And a copy of the bid of the present petitioner is also enclosed,
Oh,
my lord.
everybody was same.
Everybody was same in the financial bid, my lord,
Where
including
is
the present
the
petitioner.
comparative statement?
That is not available with us at this stage, my lord, but we have enclosed the copy.
Even after 4 months from the file of the repetition of the tender being settled, you don't have the comparative statement.
My lord, copy of the bid of the present petitioner is enclosed here with my lord, page 24, my lord.
Page
24, my lord. 23 is the translated, my lord.
What is this?
Point number 3, my lord, price quoted by the present petitioner, my lord.
Yes, price quoted in the bid 34,650.
Same price.
Hello?
He also filed a representation. my lord.
Madam, you, why you are making so many a party?
My lord,
Madam, you can accept notice for 1 to 5. Issue notice making it returnable on 21/11/2025. Miss N. Bora. You can serve this person by way of the street.
That's the OBC, my lord.
If you can't, then we have it sometime on 28th.
Okay, my lord. We'll serve by Dusty, my lord.
Huh?
We'll serve by Dusty, my lord.
Okay. The notice making it returnable on 28/11/2025. Miss N. Bora accepts, the Standing Council of the PNRD accepts notice on behalf of the respondent numbers 1 to 5. As regards the extra copies of the writ petition be served upon her during the course of the day. As regards the respondent number 6, petitioner is directed to take steps by speed post during the course of the day. So in addition to that, the petitioner is also given the liberty to effect service upon the respondent number 6 by way of the street, rooted to the registry of the spot and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner, along with various other bidders, participated in a notice inviting tender dated 26/5/2025 for settlement of a parghar in the namely Moinbori Pub Bazar to Pam Moinbori Porghat via Kisanmat Moinbari NC. The petitioner, case 8, that the petitioner along with the private respondent quoted the same rate and the respondent authorities without following the mandate of
NIT, my lord.
what NIT? There is a provision in the this department also, na? Lottery? Where is the lottery business?
That is there in page 15, my lord. Copy of NIT is enclosed.
Without following the mandate of the notice inviting tender, more particularly clause
13, my lord.
13? Where?
Page 15, my lord.
Which one?
The first one, page point 13, my lord. In case of more than one
15.
bidders.
The settlement was made in favor of the private respondent number 6 by an impugned order dated 18/7/2025. It is under such circumstances the petitioner has approached this court by filing the instant writ petition. The learned counsel appearing on behalf, do you want to stay? No stay.
We want, but
Learned counsel appearing on behalf of the petitioner submitted that as the settlement made in favor of the respondent number 6 is contrary to the notice inviting tender, more particularly clause 13 core, the impugned order dated 18/7/2025, be stayed pending notice. This court duly takes note of that the petitioner has approached this court after a period of 4 months. And as such, it would not be in the interest of justice to stay the impugned order dated 18/7/2025 without giving the respondents an opportunity to place their case. Accordingly, this court directs the respondents to bring on record their stand by filing their affidavits on or before the next date. It is observed that if no instructions are placed before this court shall consider the passing of interim directions.
57.
Yes, what is this?
My lord, this is against the demolition order. My lord, what happened, the petitioner purchased land, my lord, in the Kharguli, 4 kata 17 by 3 cell deeds.
Huh?
3 cell deeds. And
What land?
for residential,
Okay.
for 3 cell deeds, 3 dark numbers. 407, 408, 409.
From
Now-
by three sale deeds,
3 cell deeds.
three different dark numbers.
No, my lord, the dark numbers in one cell deed, 2 dark numbers are there and other cell deeds different. Now, he applied for, my lord, building permission, ground floor, basement and ground floor by the my lord, application dated in 2007.
Where is the permission?
And then permission was granted, my lord, in this matter, that is page 46.
Page
46. This is for the,
46.
yes. For ground and basement, there is no
Okay, ground and
basement.
basement.
Yes.
Okay.
Now, my lord, again, my lord, 2009, he applied for another, my lord, along with another drawing for construction of a second basement, small room for ground.
How many basement can it be there?
My lord-
Second basement means?
My lord, river side, na?
Oh, yes. Okay.
Hill. My
So
lord,
this he applied when?
applied in 2009, my lord,
Okay,
16
then-
March 2009. Your losses may just see page, my lord, the drawing, my lord, at page 48,
Ah.
left-hand side, my lord.
Hmm.
This is the, my lord, drawing. Here, my lord, is a small room, my lord, servant room in the second basement. Then ground, then the first and second. This is, my lord. Drawing is changing, my lord.
So earlier it was ground,
Ground and first,
basement.
basement and ground floor.
So
Basement
now
and
you want to have one
floor.
basement below,
My lord, one basement below and
one basement up.
one
One floor up.
first floor up,
So now it will be four story.
4 story. The second basement is only one, my lord, small room, that is ground floor and others. Now here, my lord, they have not replied to this, my lord.
Huh?
No reply to this application.
Then
Then dim permission, my lord, we constructed. We constructed, we are residing there since 2009, my lord. And now it was
you
assessed
constructed in the year 2009.
9.
Okay. How can you construct in 2009 when your document which you are enclosing
Yes,
shows that the building was year of construction is 2014?
it was, my lord, it was assessed in 2014, my lord.
Huh?
It was assessed in some, my lord, the works here and there, but they are residing, my lord, there in the building within 2000.
Kindly come to page 50.
Page 50, yes, it was 2014, my lord, it was assessed. It was assessed.
So you made it in 2014.
Actually, my lord, it can be, but they are residing in since 2009, my lord.
Maybe, but
yes.
Here it says
Yes.
year of construction,
Yes.
G+2,
Well,
year 2014. Then you
Now
submitted your.
we are paying the, my lord. Now, this letter was issued, my lord, for submitting the documents, we have submitted the document.
What is the ground name? is-
My lord, one neighbor complained, my lord. Complaint of Rimjim Mohanto. My lord, what happened in there is a, my lord, actually garden, and garden, my lord, some extension was there, my lord, in the boundary. For this, my lord, this complaint was made, actually.
Complaint has been received against construction of the RCC building by violating the norm. Okay. So a copy of the complaint was given to you?
No.
Then
Then, my lord, we submitted the
again,
documents.
show cause is being issued.
Stock was issued.
Now therefore, you are asked to authorize.
Then, my lord,
So cause undersigned on receive as to why the irregular here. What is the irregular is being said? Thereby contravene the provisions of 25 and 26.
yes.
Further, the issue of encroachment of land as mentioned is to be settled in the appropriate forum and the deviation in construction on the approved building
My
plan.
lord. My lord, what happened, my lord, Rimji Mohanto, she has,
Violation in setback, construction of RCC slab, violation of setback, manner of construction detail, violation of construction of RCC in the north, no objection to building submitted basement. Construction is basement plus ground plus. You made basement plus ground plus 3.
not three, my lord, my lord, this is the drawing. And in fact, my lord,
Mr.
they have
Sehra,
made
one
it.
thing I don't know, but how can there be a basement and below that another basement?
No, the basement and one below basement is there, my lord, because in the hills, my lord, it can be, my lord. There is no difficulty, my lord. Because, and moreover, in
Means
above,
basement, below basement has to be, there has to be the roof of there.
roof.
Don't you think a basement will require roof?
Roof is, my lord, the basement roof is there, below basement. The first basement roof is there.
No.
And below the first basement, my lord, that room is there. This is for survey.
So this is being done.
This is being done. My lord, now they know above 3 floors, my lord. Virtually now. Now what happened? The Rimjim Mohanto enclosed land, 3 lacha land of petitioner. That is why, my lord, he submitted complaint to circle officer for measurement of land, and that is why it was made, my lord. Ultimately, my lord, there was a hearing, and hearing that your losses will see, my lord, at page, my lord, 64, my lord. That is the minutes of the meeting. That is the important one. Page 64. After this, my lord, they have, by page 67, they have revoked the building permission granted for the ground and basement and ground also. By this letter, page 67. Then, my lord, page 68. Then, my lord, there was a survey. In the survey, it was found, my lord, about 3 lacha land is enclosed by Rimjim Mohanto.
By?
Rimjim Mohanto, the complaint who has filed. That is at page 73, my lord. Seen under position of Kotha 3 lacha. Where is her land is page 73.
Page 73.
Yes. Survey plot marked as A. It belongs to, my lord, Rimjim Mohanto, 2 katha 3 lacha. Whereas as per Seldin, my lord, she has 2 katha and 60 square feet.
What is as per ROR?
You are not to be here. Is 67 not? The revenue record it to be a
Where did that, somebody else has encroached your land?
My lord, from the drawing, my lord, we have submitted additional affidavit also. My lord, at page 75, your lordship will find, my lord, this is A. A is the, my lord, the complainant's land. Her land is shown to be 2 kata thilta. Whereas as far as her sell deed, my lord, I have submitted a additional affidavit that her land is, my lord, total land purchased by her is 5814 square.
Yours is not your land, his land is A, 2 kata, 3 acres.
That is her land, my lord.
A.
Yes. And my land is,
That is besides the point.
yes.
Well, the
And-
fact remains that your case is that you have got you on the basis of deemed permission.
Yes.
In terms of section 25,
Yes.
and they have not taken into consideration.
No, that was not taken into consideration. And secondly, my lord, so far the other, my lord, part, garden, my lord, wall is concerned, my lord, that is negligible, my lord. But she has encroached 3 charge of land. That is 407.
But whatever may be,
Yes.
your basic case is that you have got the permission from here.
Well.
But how? Yes, Mr. Naik, how you can direct the entire building to be demolished?
Yes. Lordship, next it comes to the building permission lordship at page 46. Lordship, it was issued in the year 2008. It was for basement and ground.
That I've seen.
Basement and ground.
Ah.
If lordship comes to the drawing lordship at page 48. And if lordship looks at the picture at the middle lordship, that is not elevation.
Ah.
One GL road line is there, one ground line is there lordship. GL. So one basement is already there. So this is the ground level, it is the first ground level. So he applied for the first floor.
Applied for the ground level.
The basement was already there in 2009.
Basement and ground level.
So-
So in north elevation,
No, as per the approval of 2008, this basement and ground level was already there. It was approved. In 2009, as per his submission, this first floor was applied
first floor over,
over the ground.
over the ground, yes, applied.
So now it will become basement plus 2, basement plus ground plus 1. Now lordship will see the violation. Page 52. Page 52, annexure C. Lordship may kindly see type of violation. Manner of construction, lordship, basement plus ground plus 3. It should have been basement plus ground plus 1. Now he has basement plus ground plus 3. Second violation, violation in setback. Construction of RCC slab in north setback area, that is the complainant side lordship. In that portion lordship, his projection is 0.36 meter inside the boundary wall of the complainant. Rightly or wrongly lordship, he is in possession of 3.2 kata. Other party complainant is in possession of her land. Now he constructed a projection lordship inside the boundary wall of the complainant, and that is around 0.36 meter. So there is no zero setback plus inside the boundary wall of the neighbor. Third, lordship may kindly see no objection certificate NOC for building permission submitted for basement plus ground.
All are understood, but how do you demolish the entire building?
Lordship, one proper hearing was given.
No, proper hearing, no proper hearing. He has the permission for basement plus ground.
Lordship, one, it was there. If lordship comes to page.
How can you recall that permission?
Page 67.
No, if an permission has been acted upon, how do you recall that permission?
Page 67, section 33 is there now.
Yes.
Now, if lordship comes to the last paragraph, now therefore, I so and so, Chief Executive Officer of GMDA, as per the powers conferred in this authority under section 33 of GMDA 1985, do hereby revoke the building permission number so and so dated 29/4/2008. So the original permission has been revoked.
Now, where is the notice for revoking?
No notice.
Where is the notice for revoking?
Notice lordship, two notices lordship will.
No, all notices are there. There is a violation. But where is the notice for revoking? You have constructed the building. After construction of the building, there is already another building.
Yes.
Building has been constructed in 2009, year of construction has been shown is 2014. What do you mean, rightly or wrong? But thereupon, without a notice, how can you act in terms of 33 permits to revoke? That is another aspect. We'll have it at 2.
Lordship.
In view of the above analysis, we do not find any infirmity in Rule 15 of the Rules of 2017 to exercise the powers of judicial review. Accordingly, we dismiss the instant writ petition and vacate the interim order. The respondents would be at liberty to take appropriate steps for giving effect to Rule 15 of the Rules of 2017, if so advised. The registry shall return the record back to the Kohima bench.
Principal seat for delivery of judgment, item 52.
The writ petition lacks merit and accordingly stands dismissed. In view of the above analysis, the respondent authorities, more particularly the respondent number 4, would be required to recast the select list dated 18/2/2024, thereby migrating Srimati Sumona Paul, the respondent number 8, against the post reserved for women in the unreserved category and deleting the name of Sri Liton De, the respondent number 9 from the select list. The respondent number 4 would also be required to include Srimati Ruby Nath against the post reserved for women in the OBC/MOBC category, more particularly in view of the migration of Srimati Sumona Paul, the respondent number 8, to the unreserved category. This court directs the official respondents to do the needful in that regard. There shall be no order for cost.
Deeply.
But Mr. Das, have you, what affidavit you have filed? I didn't look in the, while hearing, I didn't look into that affidavit. An affidavit is being filed on behalf of 6 to 16, which includes Liton Dev.
Yes.
As well as Sumona. Liton Dev himself says that, look here, I should not be there. Isn't it? No. He should have been brought out. Don't you think that? Although I have not put that. Yes, what notice did you issue?
Yes, before that, Lordship, if Lordship comes to page 88, that is the order, Lordship. I don't know, section 88 order. 68, sorry, 68.
16.
68.
60.
If Lordship comes to the schedule below Lordship. So we are not going for the entire building, Lordship. First floor, second and third floor over the basement and ground floor. So demolition order only in respect of the first floor, second floor and the third floor.
No, but you see the order at page 68.
Yeah. That is what, Lordship.
You say see the schedule, entire first floor, second floor,
Yeah.
third floor over the ground floor plus ground.
No,
Yes.
over the basement plus ground.
Over the basement plus.
So we are not touching the basement plus ground floor.
But this is what is the order it is.
Yes, Lordship, I enter first, second and third floor.
Over the basement plus ground floor.
So first, second and third, which is situated over the basement and ground floor, we are going to take action. Not the first floor, not the basement and the ground floor.
Finally see, now therefore, in view of the paras, I so and so in exercise of the powers under year order to demolish the RCC building D plus G plus 3. So and so as detailed in the schedule below within 3 days of the issue of the order to demolish the following so and so, so and so, so and so.
As detailed in the schedule. So this is the schedule, Lordship. So why I am saying this, Lordship, initially he got approval for basement plus ground. Subsequently in 9, one application was filed, but my system is showing that it was rejected in the year 2009 itself. That second application for the first floor and additional basement. If Lordship comes to this map, Lordship, drawing Lordship. This is the drawing, Lordship, may kindly come to the second picture, Lordship, in the middle, Lordship. So basement was already there. Ground floor was already there.
Yeah, basement is, you see, GL Road.
GL Road is the ground level.
Is the ground floor. So
Above
this is the ground
level,
floor.
It is the ground floor.
Ground floor.
He
Then
applied-
down below will be the basement.
That is the basement.
So these two are the okay.
So far as approval of 2008 is concerned.
So these two are okay.
Now, Lordship, he has applied for the additional basement,
So he asks for below that basement, there is another portion.
another portion. And
So this
above
one and on top of it,
One-
these two.
One first floor. Ground level.
So,
ground
so
floor,
there is one first floor and then there's no, nothing else.
Nothing, that is the staircase.
Ah.
So ground floor
So
was.
there is only one floor, which is,
Yes.
one floor which is bad.
By applying in 2009, he applied for one additional floor, that is first floor.
So that is one,
That is
and
one.
then down below one.
Down below one, another basement.
Another.
So this application was rejected, it is showing in the system, Lordship, as rejected. So at base, even if he is saying that my approval was deemed approved, he cannot go beyond that first floor. But in this case, Lordship, the building is ground plus basement plus ground plus 3. So above the first floor also, above the ground floor, there is another 3 floor. And above the first floor, there is another 2 floor. So in any case, Lordship, even if the 2009 application is presumed as deemed approval, Lordship, 2 additional floors are unauthorized. Even in that case also, Lordship. But my system is showing 2009 application has also been rejected. So this first floor is also unauthorized.
But did you intimate about the rejection?
Lordship, rejection is a different. On the basis of the rejection, we are not taking any action. Although
No,
the
because that's what you are saying, it has been rejected in 2009.
Lordship, two
That is
orders.
not a part of your order.
Lordship, 2 orders were passed, Lordship. One at page 67, Lordship. That is the revocation of the building permission of 2008. Lordship,
This
on,
is without notice.
even if it is without notice, Lordship, the section 33 has no provision for giving any notice.
No,
We
that
are
has to
not-
be inbuilt.
Lordship, I am not taking this phase at this stage, Lordship. On the basis of this order, Lordship, we have not yet taken. any
Let us
action.
see what is section 33, how that. এই GMD এখন কোন GMD এখন দিয়ক এইখন ওপৰ পানী তলত স্বামী যে আছে স্বামী তলত গুৱাহাটী মিউনিচিপাল তাৰ তলত এইখন
Page 629.
So 33A says what? Read 33A.
Yes, that I read it.
So
If
30,
the operation
this
is wrong,
order of revocation is wrong.
Lordship will issue notice to that extent, Lordship. Look, what I am submitting at this stage, Lordship, two orders were there. One at page 67,
The 67 is bad.
Lordship will actually.
No, it categorically says under 33A, if it has already been constructed, then you cannot. The power is given for revocation only to them.
That extent, Lordship will issue notice and Lordship will execute.
Then next.
If Lordship comes to 68,
Hmm.
Lordship, Lordship, we are not going for the basement and ground floor. We are only in respect of first floor, second floor and third floor. Plus cantilever projection in the first floor of 0.36 meter in the north setback. That is the boundary of the complainant. Zero setback in the north side. Setback to be maintained 7.40 meter and 13.10.
Sir, Mr. Sahibullah,
Yes.
tell me,
Well,
they are saying as G plus B plus G plus 3.
no, this is wrong, my lord. If your lordship see assessment order, page 60, 50. Left hand side here first.
Parking,
Basement floor, ground floor, first floor. And another, my lord, this is a small room they have assessed at so and so, 11.
where?
Right hand side,
Ah.
SRCC, my lord,
Basement floor,
110.
Ground floor, first floor.
Ground floor, first floor, my lord, nothing more than that. What drawing is given, my lord, that is the only floor, my. How they have, my lord, saying the second floor, third floor, I don't know. There is no second floor, third floor.
So they are taking that floor,
Yes,
which you have made below the basement,
yes,
as the basement.
basement.
And then they are making it G
Yes.
plus G plus G plus 3, B plus G plus 3.
Yes.
Means they are having, you are having 5 as per them.
Yes,
B, G, 1, 2, 3.
yes.
5.
They, as per them, they 5, it is 4, my lord.
1, 2, 3.
While assessing, my lord, they have take measurement all the everything. Everything is there. As I am sure of this.
And where is your statement as regards deemed permission in your reply?
Yes. My lord, in
Reply
fact,
to the show cause?
no, my lord, here, my lord, in fact, in the argument, we have said in permission, but they have said that permission is there. That is wrong, my lord. At page 64.
Wait,
Page 64. My lord, that was pervert, my lord.
Revision
actually.
of plan and deposited the requisite fee for which a receipt was there. He claimed that the revised plan was approved,
Approved,
but
that is not
apparently
correct.
untraceable.
We said deemed permission. my lord.
He also alleged that so-and-so had encroached on his land resulting in reduced possession as per his land document. However, his reply was not as he could not produce the entry for the construction of the first, second and third floor of the residential building. But what you have stated in this order
Yes.
is that you have that permission, but it has been lost.
My lord, that is not correct, my lord. In fact, he has said deemed permission.
Where is that?
That is not there here, my lord.
No, where have you written anywhere? That is never your stand.
My lord, actually, it is, if your lordship see, my lord, at page 69, my lord.
Yes.
Para 2.
So here you have written. So after this, they have not done anything, no?
No, subsequently, my lord, yesterday we got, but we
Now,
came,
when you submitted this 2/9/2025,
yes. Yes. Yes, sir.
where is the order for demolition?
The demolition, my lord, it is on
26/8.
Yes.
So what is the urgency today?
No, my lord, the urgency, my lord, we came to know, my lord, that they are operating, my lord, for subsequent affidavit has been filed, my lord.
When?
We have collected a copy of the order. Yesterday it was served on us.
Huh?
Yesterday it was served on us. Page 83, my lord.
This is again 27/10.
2710, but they fixed it on 10/11, my lord, for demolition at 10 AM. And they inform, my lord, the electricity and other all departments, police and other, for the purpose of that.
Rightly so. So going on 25-4.
Yes, ma'am, 25-4.
Yes, Mr. When can you file your affidavit? I'm going to grant us to.
In respect of the ground and first floor.
No, no,
Or in
because
respect-
what is happening is he says it is basement and first floor he had taken the permission. Then down below, he has sought for another permission for purpose of construction
Basement and first floor.
below the basement,
Below the basement,
another
plus
basement
one
and then
floor
first floor.
above the ground floor, yes.
Now what you have taken is G plus 1 plus 2 plus 3.
We are not going for ground floor, we are going for the first floor, second floor, and the third floor. It is
No.
quite clear from the demolition order.
No, 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 it is
Lordship,
not
I
so.
kindly see once again, Lordship.
And
68.
we will also see as to whether you have intimated his rejection. Otherwise, what do you say about 25-4? You have to intimate when he files an application. If you don't intimate him that rejection, then obviously it will be deemed.
Lordship, I kindly see the minutes of the meeting. It is dated 11/7/2025, page 64. So that was the minutes after the hearing wherein the petitioner as well as the complainant were present.
Now there it is being mentioned that he lost it.
Yes. So
Revised plan was approved, but it was currently untraceable.
so 11/7/2025, the outcome of the meeting was minuted. Signature was there. Lordship, thereafter, Lordship, on 26/8. So
Where is the complaint of Rimjim thing?
that complaint I am also looking for, Lordship. In fact, it was filed, that assessment was in the year 2014. Complaint, first notice was issued in the year 2024, July 2024, after receiving a complaint from the complainant, Lordship.
In 2000?
24. So first initiation was in the year 2024, July. So from 14 to 2024, in between these 10 years, he constructed the another remaining 3 floors.
No,
Additional
no, it is as per the assessment.
assessment, it is only ground plus first is there.
Yes, so is it any other construction?
Yes. So
It
that
can't
is
be.
our, that is our complaint, Lordship.
Okay, next step you produce the photographs.
Yes,
Then where is the basement?
Basement is there, it is intact. Basement we are not going to touch. Ground floor also we are not going to touch, Lordship. Only the first, second and third. I mean, whatever is there above the ground floor.
issue notice making it returnable on. Why do we need Rimjim Mohanto now? Yeah,
She is the complainant, we made for
but her complaint is what? What was the complaint for?
unauthorized construction plus construction.
No, her is construction over her area.
Yes.
That is the only thing.
That's it.
No, but if there is an encroachment upon her area, you can demolish it. I have no problem.
That starts from the first floor, Lordship.
That, if, as regards the setbacks, you can demolish it, but you cannot demolish the building otherwise.
No, Lordship, if somebody constructing a building, Lordship, inside the boundary wall of the
Mr.
neighbor,
Nayak,
Lordship,
you are aware that I'm very strict as regards unauthorized construction. But if the mandate of law 25(4) says about beam construction or not, whether he has submitted that application and whether you have rejected and intimated to him, the moment you show me that, I'll immediately ask for dismiss the petition.
Lordship, that
But the
rejection,
only confusion is, he says it is ground plus B2 and one above.
Yes.
That is his case. Whereas your case is, it is B plus G plus 3. So therefore, it appears that there is a big difference. So let us therefore ask your petition
let me just repeat, Lordship. Basement plus ground
plus
approved in 2008. Then he applied for revision of the permission.
So is there any construction below that basement? I'm asking you. Below the basement, whether there is a construction. This is what he is saying. He has constructed below the basement. Yes, whether there is a permission or not, whether that has been approved or not, that is a different aspect of the matter. But below the basement, whether there is a construction, or is that the construction out there you are considering to be the basement? And thereby making it ground plus B plus B plus G plus 3.
Lordship, whatever basement is there, we are not going to touch. Even if it is one basement in.
We'll
terms
see,
of
no
capacity,
heavens will fall.
Or
It
another
will
basement
work
in
for
terms
so
of
many years.
2009.
No heaven. We'll have it. Issue notice. How much time?
2 weeks. Lordship.
Issue notice making it returnable on 24th of November 2000. You'll file it within 2 weeks. Affidavit?
Lordship. Lordship, if possible, Lordship, on 21st, Lordship, 22nd, Lordship.
22nd is closed. Saturday. On
21st and Lordship.
21st,
24, 25.
difficulty.
I'll be out of session.
26. Can you file your affidavit by 25th, 19th?
If it, I can definitely file.
By 19th, you file your reply. I give them the time to file the reply by 26th,
Yes.
and we have it on 27th.
Yes, my lord.
And you produce the photographs.
Yes, my lord. Photographs as well as my lord, other things will write.
Notice making it returnable on 27/11/2025. Mr. Inay, the learned additional advocate general, accepts, who is also the standing counsel of the Guwahati GDD department, as well as the Guwahati GMDA, accepts notice on behalf of the respondent numbers 1 to 4. Ms. Yudas, the learned additional senior government advocate, accepts notice on behalf of the respondent number 5. Extra copies of the writ petition be served upon them during the course of the day. As regards the respondent number 6, the petitioner is directed to take steps during the course of the day by way of speed post. And further, the petitioner is also directed to take steps by way of dusty and file an affidavit routed to the registry of then file an affidavit of service on or before the next date. The petitioner herein is aggrieved by the orders dated, by the minutes of the meeting dated 11/7/2025. Order dated 26/8/2025. Orders dated 26/8/2025. As well as the subsequent order passed on 27/10/2025 issued by the Chief Executive Officer, Guwahati Metropolitan Development Authority, whereby directions have been given for demolition of the following. Number one, entire first, second, and third floor over the basement plus ground floor. Number two, cantilever portion in the first floor of 0.36 meters in north setback. Number three, zero setback in north side, bracket setback to be maintained 7.40 meters and 13.10 bracket close. Premises dash Bangkong BANKONWAR Tila Kharguli. The case of the petitioner herein that the petitioner had purchased by three different deeds of sale a plot of land at measuring 4 kathas 70 lechas, a conjoined plot of land at measuring 4 kathas 17 lechas in various dags and patta numbers. Thereupon, the petitioner applied for permission from the GMD authorities on 23/11/2007, seeking permission for construction of a residential building. The permission was accorded on
29th April 2008.
29/4/2008 for ground floor and basement. And further mentioning therein the setbacks on the four different boundaries. The petitioner thereupon submitted another application on 16/3/2009, thereby seeking further permission for construction of one floor below the basement and one floor above the first floor, ground floor. It is the case of the petitioner that the said permission, though applied for, and payment duly made, the respondent authorities thereupon never, respondent GMD authorities therefore thereafter never intimated the petitioner about any rejection of the said application. Under such circumstances, in terms with Section 25(4) bracket 4 of the GMDA Act 1985, it is the case of the petitioner that the petitioner had a deemed permission to construct one floor below the basement and one floor above the ground floor. The petitioner thereupon duly made such construction, and the same were completed sometime in the year 2014, which was assessed by the Guwahati Municipal Corporation by an assessment order on 6/6/2014. On the basis of a complaints, the petitioner were issued certain notices, and the petitioner thereupon replied to the same. On 11/7/2025, a meeting was held wherein it was recorded that on the issue pertaining to land encroachment of the petitioner's land by the respondent number 6.
Yes.
6. The same would be decided by the appropriate forum. However, it was found that the construction of the first, second, third floor was in violation of the approved plan without NOC and is to be treated unauthorized. An appropriate order may be issued by the authority as per the GMDA Act 1985. Subsequent thereto, on 26/8/2025, it is the case of the petitioner that the respondent, the chief executive officer of the GMDA issued an order whereby revoked the earlier approved plan, earlier NOC so granted in exercise of the powers under Section 33 of the Act of 1985. On the same day, an order was passed thereby by the Chief Executive Officer holding inter alia, thereby directing inter alia to demolish the residential RCC residential building bracket B plus G plus 3 of the petitioner within 3 days from the issue of the order for demolition of the following violated portions, failing which the GMDA would be free to go ahead with the demolition process and the cost of the demolition shall be recovered from the petitioner. It is categorically mentioned in the said order that what is to be demolished. It is seen that the directions which were passed for demolition were number 1, entire first floor, first, second, and third floor over the basement plus ground floor. Number 2, cantilever projection in the first floor of 0.36 meters in north setback. 3, 0 setback in north side, bracket setback to be maintained 7.40 meters and 13.10 meters, bracket close. The petitioner, on coming to learn, had submitted a representation on 2/9/2025. However, there was nothing done. On the other hand, on 27/10/2025, an order was passed by the Chief Executive Officer of the GMDA, whereby it was informed that the unauthorized construction so carried out by the petitioner would be demolished on 10/11/2025, and it is under such circumstances the present petition. Mr. G.N. Sahewala, the learned senior counsel appearing on behalf of the petitioner, submitted that the question of revocation of the NOC so granted in the year 2008 after the construction having been carried out not only is in violation to the principles of natural justice inasmuch as there was no show cause notice was issued prior thereto, but also is contrary to Section 33(1)(a). 33(1)(a). Of the GMDA Act of 1985. The learned senior counsel further, referring to Section 25(4) of the Act of 1985, submitted that the petitioner duly submitted the application on 16/3/2009 for construction or seeking permission for construction of the one floor below the basement, already permitted basement floor, and one floor above the ground floor. The said application was neither rejected nor any such rejection was duly informed. And as such, it is the case of the petitioner that the petitioner had a deemed permission by virtue of section 25(4) of the Act of 1985. The learned counsel, senior counsel further submitted that it is unthinkable as to how the respondent authorities have unilaterally, without any notice, revoked the permission already which was granted in the year 2008, and thereupon have directed demolition of the entire building, which is B plus G plus 3. He therefore submits that this is a case where the respondent authorities have acted in a most arbitrary manner and requires interference. Per contra, Mr. P. Naik, the learned counsel appearing on behalf, learned additional advocate general appearing on behalf of the respondent, submitted that the petitioner had the permission to construct only the basement as well as the ground floor. However, the petitioner has not only constructed the basement, the ground floor, but 3 floors above. And as such, the construction was absolutely illegal and unauthorized, and for which it is necessary that this court, for which the action so taken by the respondent authorities ought not to be interfered with. The additional advocate general further submitted that the order dated 26/8/2025 is only limited to demolition of the entire first floor, second floor, and third floor, and not the basement plus the ground floor. He further submitted that as regards the cantilever projections as well as the maintaining of zero setbacks, it is categorically even mentioned in the original permission which had been granted in the year 2008 that the petitioner was required to maintain such setback on the north side. And therefore, he submitted that this is not a fit case where there should be any interim orders passed. Should I put that you have instruction that under your system is this? Huh?
I'll file my affidavit.
No, should I put it in your submission?
Otherwise also, if your lordship is passing the interim order, it will be of no use.
No, but this is your submission. Do you want that I should put it
What I have
on?
been already instructed, Lordship.
No, but the question is, you have made the, whatever you have submitted, I should put it. Do you want, should I put that thing that in your system, it has been shown that the petitioner's application was rejected in the year 2009?
Yes, that was already.
Mr. Pina further submitted, the learned additional advocate general further submitted that from, as has been informed to him verbally, the very application which was submitted by the petitioner in the year 2009 was rejected in the year 2009, which is still appearing in the system of the GMDA. I've heard the learned counsels appearing on behalf of the parties on the question as to whether interim directions are required to be passed in the present case. From the materials on record, more particularly the order dated 26/8/2025, orders dated 26/8/2025, it is apparent that by one order, the chief executive officer of the GMDA have revoked the permission which was granted on 29/4/2008. And it further appears, subject to materials being placed before this court by the respondents, it prima facie appears subject to materials being placed before this court by the respondents that the same is not only in violation of the principles of natural justice, but also violates the mandate of Section 33, 1A of the Act of 1945, 85. This court further takes note of the order dated 26/8/2025, whereby the Chief Executive Officer of the GMDA have directed the demolition of B plus G of the entire residential building, that is basement plus ground floor plus 3 floors above. On the other hand, it is the specific case of the petitioner that there is no building in the as have been mentioned in the order, inasmuch as the building in question is basement is basement plus ground floor, basement, ground floor and first floor. And there is an additional basement of a small servant room on the below the basement floor. This aspect can be learned only from certain photographs being placed before this court as regards the building in question. Liberty is given to both the parties to file appropriate photographs of the building before this court by filing additional pleadings if so required. If so, liberty is given if so. This court also cannot brush aside that petty aspect as to whether, as regards the deeming provision provided under Section 25(4) of the Act of 1985, which stipulates that if within 30 days of the application, the permission is not rejected, it shall be deemed that the permission has been granted. Under such circumstances, it is the prima facie opinion of this court that, and it is therefore the opinion of this court that the subject matter of the dispute requires to be preserved till the next date. Accordingly, this court therefore directs the respondent authorities, more particularly the respondent number 4. Respondent number 2, 3, and 4.
Yes.
Not to take any actions in pursuance to the orders dated 26/8/2025, as well as the order dated 27/10/2025 till the next date. The respondents are directed to bring on record their stand by filing the pleadings on or before. When did I fix?
19th.
19th of on or before 19th of November, liberty given to the petitioner to file reply on or before 26th of November. So on the next date, an attempt shall be made to dispose of the writ. Mr. Naik, you inform about the stay? About the stay which I passed?
No.
Yes.
My lords, we have filed the additional affidavit as was directed, which contains the undertaking as required under clause 2224322. Does my lord have it?
Wait, please.
Hmm.
My lord, yesterday lordship just wanted to know about the undertaking which you have brought on record. That your lordships will, we have filed an additional affidavit. It starts at page 292. And the undertaking is at page number 295.
So you have not given an undertaking. You have said that the provision is bad.
Without prejudice to our rights, we have given the undertaking.
No, you have not given that undertaking that
No,
there
my
is
lord,
nothing.
second page, 296. Last para. Accordingly, undertaking is given. This undertaking is without
No, no,
prejudice.
what is your undertaking? You see, kindly see paragraph 2.
No, that is the whole case is, Lordship will kindly appreciate if your Lordship kindly comes to the undertaking, the second sub-para. We have clearly explained that the qualification requirement under the above referred clause 2.2.2.4, etc. read with remarks in reply to the pre-bid query so and so. Clarification has been incorporated in the revised RFP. Collapse of superstructure, structure pertain to design failure or quality related failure of permanent structure would be considered in this clause only is patently ambiguous, unenforceable, and merits declaration as being void under section 29 of the Indian Contract Act and also being violative of article so and so. My lord, why we are saying this, kindly appreciate. Now, there is no clarity, it's as vague as anything. Now, collapse could be on account of design failure, collapse could be on account of faulty construction. Now, it is attributable to what? It is in this situation, my lord, in my humble submission, this application of the principles of natural justice assumes significance. As has been held in Atlanta and all these cases, my lord, you can't resort to such a clause whereby you will, that's why it is said it's a civil death. Without being, being subjected to any, my lord, process of, examination, if you apply the principle, my lord, then it's a civil death. Now, end of the day, my lord, the Patna High Court litigation was closed. Our plea was accepted. We continued with the work. For example, my lord, Lordship will kindly see today we are undertaking this construction. We have already completed the second bridge over Bhramuraguri. We are undertaking the second bridge in, my lord, Panchatantra, that Jogigopa bridge. We have recently given another work of 1200 crore, that is connecting Kamakha station, Azara and Kamakha. And kindly see, my lord, this
All in Assam.
in Assam. And but most importantly, very recently, they're also giving, I think, that Majuli bridge. Majuli also.
All Assam.
Not by railway. Majuli is not by railway.
It seems there is a similarity with the flyovers and your overbridges, the overbridges.
No, my lord, therefore, all that we are saying is, my lord, if we go by the interim order given by the learned single judge on the first occasion, my lord, that was that they should consider our case. Now, while considering,
but the fact remains,
yes,
this is the term of a contract.
yes,
This being a term, they may very well put a term to that effect.
yes.
If they find something infringing, where the natural justice kicks in, if they find something which is infringing, which is not being spelled out by you, then there is a requirement of natural justice.
No, my lord. Can I put it this way? My lord, insertion of this clause per se may not be assailable. But all that we are saying, my lord, means very well, my lord. If a contractor has a faulty background, if he has a, record of collapse, certainly, my lord, that's a consideration is relevant. Who is disputing that? We're not doing that, my lord. But my lord, all that we are questioning is the manner in which that clause is sought to be made applicable in our case.
No, you came.
No, kindly see, my lord. We came at a stage when we saw this clause. We apprehended that they might use this clause against us, in fact, which they did.
But you said that you didn't give an undertaking to that effect.
We have given an undertaking. Our undertaking is without praise.
Your undertaking is not that there is a no construction, nothing to that effect. You said that this clause is bad.
No, No, we, not only that, we say we give the undertaking. Because we say, because that collapse which took place in Patna, that is not attributable to us.
That's okay.
Yes.
That's okay.
So, my
but
lord,
question
now,
comes
now,
out here.
if the collapse is attributable to the design failure, as is clearly spelled out from the Patna High Court order, which they are doing a redesign, that means, my lord, it is a design failure. How can that be attributed to me?
But
Where is the finding?
Where is it in your undertaking to that effect?
My lord,
Where is it in your
no,
undertaking?
in the undertaking, we say the clause is vague. Because we do not know why, on what situation, how you are going to apply this clause to us. Is it your case that collapse is, if the collapse is attributable to the, contractor, then yes. There's nothing like that. They only say if there is a history of collapse. Collapse is on account of what? In what circumstance the collapse took place? All this must be spelled out. Therefore, my lord, if a notice would have been given to us, then we would have explained the position.
So therefore,
Yes.
you approach before the notice.
No.
Yes.
Question is, no, my lord, they have inserted a clause.
Clause otherwise is okay. But the question is, therefore, if you see.
Clause is otherwise okay in the, all that we are saying is, my lord, kindly appreciate
Yes.
what we are trying to, submit for lordship's kind consideration is, in a given case, a clause of this nature may not be irrelevant. We are not saying that. It may be relevant. If a contractor has a record of collapse, certainly, my lord, that may be a point against him. Therefore, such a bit may not be considered by the employer. I'm not on that. What I'm saying is, my lord, that there has to be some clarity in the clause. That if the collapse is on or because of your fault, then yes, you are debarred. If the collapse is on account of
So
something.
that will only come at the second stage if they reject.
Now, my lord, if we accept your lordship's, proposition, my lord, then when will they issue the notice?
They'll issue the notice. That is why I'm saying the principles of natural justice will come at a stage when if they reject it on the basis of certain materials.
Then, my lord, before rejecting, they should have
then
posed us
they-
the
they
question.
will ask you.
No, before rejecting our technical bid,
They will
then
ask
they should have given us a notice.
Because if they get some materials, they will ask you that look here.
But
because there is otherwise, if you have disclosed and you don't meet the parameters, it is okay, you are gone. But the principles of natural justice will be brought in only at a stage that after the term they find out, yes, these are the materials which we could find out. So therefore you are to be informed that look here, these are the things we have got, and as such you have not complied with it, for which you are got.
then, my lord, there is one more aspect. Assuming, my lord, lordship extends that, opportunity to them to apply that, in the given facts of the case. Now, what about the L1? What about the L2? They're also having the same record. Then how lordships will view that? They're also having within 3 years.
Very well. If they don't do, that is again.
So therefore,
no. If they don't do it, that is a subject matter.
Therefore, my lord,
is that your case out here?
therefore, in terms of the first interim order of this honorable court, before rejecting my technical bid, they should have given us a notice that we have come to notice, we have seized of the information that you were awarded a contract to build, construct a bridge over River Ganga, and there is an incident of collapse. Please explain the situation vis-a-vis this clause. Where have they done it? Without doing anything,
in your undertaking also, you have not mentioned that. What is the what circumstances you have given?
Undertaking, we have said, we will never deny that collapse did not take place. All that we have tried to explain in the undertaking is, number one, your clause is not clear. Secondly, you could not have applied this clause in the manner you have done it. These are the two aspects which were violated in our.
This is much prior to even application being done.
It's part of our bid.
You could not have applied me. The clause is there. It would not be applicable for you is another aspect of it. The applicability of the clause is different from the clause. The clause otherwise is okay.
No. This honorable court says, that's why, Miller, kindly see the order which has been passed by this honorable. This honorable court says, I think, Miller, yes.
You look into this judgment by the time I come. This is a recent judgment, it may help you. This was a case recent on 9th of
I'm grateful.
September. This was the judgment which was passed. Now, there were two aspects.
Yes,
One was pertaining to a document which was not mentioned.
in the bid
And
document.
They did not submit, but it was rejected. Wherein there were some other supplementary clauses out there that you have to submit all the documents a year, but there was no mention that this particular JV agreement was required to be submitted. But that is one aspect. But the second aspect, which is also important, is they have raised the point in the written submissions that this is another infractions to this thing and all. So it said that you can't take it up. And there you get some indication to that effect that if
At what
normally
stage?
it is absolutely the owner's wisdom
Yes.
in respect to what are the terms. Now, if the terms are made in such a manner for any terms can also be challenged, whatever may be, those terms can be challenged. But to participate in challenge is again another big problem. Now, if while doing it, some new materials are being brought in or anything comes to the notice and no notice is being issued, then it leads to violation of that. There you have the natural justice aspect. So I found that this judgment which may help. you.
And Lord, here in this case, having regard to the judgment, what I would like to submit is, my lord, here is a case. If your lordship could kindly come to that Patna High Court order for a moment, just to appreciate the, at page number 200, my lord. Please come to page 201. Learned advocate then also informs us that agency appointed was to have the design prepared to a consultant. The consultant was appointed by the agency and the design was also sent for approval to an expert who was chosen by the state from a panel of 3 submitted by the agency. Only on expert affirmation, construction was commenced, which had been stalled due to collapsing of certain spans, which had collapsed only on account of being extra dose. That means the design which was applied, which was extra dose, as is the prima facie assumption as of now. The design would now be redone, remodeled with modified technology, and any event, since the agency has taken upon itself the liability insofar as building the collapse span with no extra cost to the government, we are of the opinion that public interest litigation can be closed. My lord, can it be said from this passage that anything is attributable to, yes, there was a collapse, where this opportunity was extended to us to explain the position. Straight away, you should not apply. These are the reasons, my lord, why a debarring clause, be it in the form of a blacklisting, be it in the form of a debarment, Supreme Court said you should not apply straight away. Now, my lord, this clearly shows that means the design which was adopted was faulty, prima facie. And that's why, my lord, the decision was taken.
Therefore, there will be some document to that effect that
Yes.
it was not the fault.
Therefore, my lord,
It
if
happened
they,
long time ago.
now, if they issue a notice to us, if your lordship remands the matter back to the authority for a fresh consideration of my technical.
But the problem arises, you did not submit the undertaking in that regard. You submitted the undertaking questioning the clause.
No, my lord, without prejudice to the rights, we submitted the undertaking.
Understood, but questioning only the clause.
My lord, it was not an unqualified, it was an qualified undertaking. Let us put it that way, my lord. It was a qualified undertaking. But the undertaking is there.
The undertaking, but what was the
No,
undertaking?
my lord,
should have-
what I am trying to impress upon your lordship is, my lord, having regard to this finding of the Patna High Court. Now, is it not onerous? Is it not, my lord, superfluous, my lord? Kindly appreciate.
But in this undertaking, there is a single word there to the effect that you have nothing to do. It was not your fault.
No,
Show me
prima
the
facie
link.
it shows.
No. From your undertaking which you have enclosed.
Ha. Undertaking, my lord, last para, my lord, at page number 295. Subject to the foregoing, it is disclosed in respect of unforeseeable collapse of part of spans on 34 to 22 or 4/6/20 in respect of Sultanganj so-and-so project under instruction of the employer therein and as per order dated of the so-and-so petition, re-execution or collapse part of the span of the work by the bidder is in progress under force majeure clause so-and-so, read with the contract agreement as a whole. Finally, the matter in respect thereof is to be resolved within the modalities of contract agreement therein as a whole. But the most important part is the employer of that contract has not blacklisted me, Miller. I'm still undertaking that project. The employer of that project, Patna project.
It is not the question of them, but here, the author of the year had made a particular clause. That look here, any breach falls within three years and anything to that effect, he cannot be allowed to be participate and an undertaking is to be.
Yes.
That's all.
And I have given an undertaking, qualified undertaking.
No, undertaking, but have you mentioned that it is not your fault?
No, Miller. Question is
That
indirectly.
is the most important thing. Then only the question will arise as you are submitting that you are putting a particular clause whereby you need certain clarification. You should have asked for me some clarification.
My
if it is
principal
necessary.
argument is such a clause per se is bad. That is the preponderance of the judicial. Secondly, here is a case where the clause is so vague. In what situation it will be applicable, what situation it will be not applicable. Not collapse per se may not be a bar. Question is if the collapse is on account of my fault, yes. If it is on a fault of somebody else, then why should I face the music, Miller? Therefore, first, such a clause per se bad. Secondly, it is vague. Thirdly, my lord, am I not entitled to, if you want to debar me on this ground, then you must pose me a question. We have come to know there was a collapse, plus please let me know what is the situation before
But
you
then
consider
when
your case.
If you are challenging the term of that contract, why you are participating in that? You should have challenged and got an order to that effect, but you sought for a consideration.
No, my lord, all that we said was on the date when we approached this honorable court, we had an apprehension. My lord, imminent threatened violation, we can always come for a read. My lord, there is no difficulty on that count.
No,
If there is a
understood.
threatened or imminent violation,
If you challenge the term, and can you come? My only question.
my lord, we on that day we have not posed the challenge per se. All that we said was this is a vague term. It may be applied to our detriment. Therefore, we made an approach.
No, are you not challenging the term?
I'm also challenging.
So if you are challenging the term.
I'm
how do
challenging
you
to the extent,
participate?
I'm not challenging as a proposition of law that you cannot have such a clause. But the manner in which you are trying to apply to the facts of the case, that is an aspect which you have challenged.
But at the manner in which it has to be applied will happen only subsequently once it is being taken into consideration.
So now they have taken. What we
Understood,
apprehended
but
has come true.
This has come subsequently.
Yes.
So therefore, if you have challenged the term, otherwise if you say that that term would not apply to me, it's okay. But it is not your
No,
case that it would not apply to you.
Chief should kindly look at the pleadings in the petition. Yes, kindly see me, Lord. We have said how in this manner you can apply. Kindly see me, Lord. Please come to para 37, my lord. It is submitted that the petitioner is constrained by approaching imminent deadline for submission of the bid. Therefore, while the petitioner is filing the instant writ petition before the honorable court on this date, given the timeline for the submission of bid, petitioner is constrained to submit its bid for the said tender in the format sought for by the respondent on a without prejudice basis. This is in order to seal and put on record its bid and to avoid its being left out from consideration by respondent. Such submission of bid by the petitioner ought not to be taken as an acquiescence by the petitioner to the inclusion of the impugned qualification criterion ought to be considered in light of the challenge raised in the instant petition and the facts and reasons set out therein. And if your lordship would kindly come to paragraph 31, my lord. It is submit at page 22. It is submitted that the impugned qualification criteria is also deliberately vague, overbroad and arbitrary, and in particular, the meaning of the critical phrase collapse itself is vague and undefined. Further, criteria does not even appear to exclude those cases where history of such collapse, if identified to fall with its scope, has been on account of force majeure or other reason, and not on account of any adjudicated fault of the prospective bidder. In such an event, it is clear that the prospective bidder remains blameless and cannot be prejudiced for an event which is not of his doing, and therefore imposing of such disqualifying criteria without just exception is arbitrary and reeks of malafide. And precisely, my lord, the L1, he is also having the same problem. Page number 238. If your lordship would kindly come to page 228, my lord. Now lordship will realize why 5 years was reduced to 3 years. This is sample news report. This is the chart we have prepared, and the contemporaneous news reports are also there.
Who is the L1?
L1 is Millard LNT and EPSCON is L2. And Millard, as far as rate is concerned, there is a substantial difference.
But they are parties here.
Yes, in the second, no, not in the first, in second writ petition, yes. Oh, they have not, because LOA has not been issued till date, Millard. LOA has not been issued.
Now, 1 and 2, you have only have the Union and the Northeast Frontier Railway in first writ petition.
Yes.
And the second one?
Second one, Millard, second one the same position, because as on that date, the LOA was not issued, Millard.
But without them, how can you make allegations?
Millard.
How can you make allegations without them?
No, Millard, once LOA is issued, then only the right will accrue to them.
No, because here you are challenging a term, not here, but here you are challenging your disqualification. The moment there is a right, it accrues upon the other side.
Millard, it is an incidental challenge, Millard. That's why if Millard, we are open to it. We have made a statement. If necessary, we'll make them. There is nothing like it.
But as on then, as per paragraph 22 of AFCONS, you have to make them a party.
Yes.
Because tomorrow,
Wait,
if
this
I
statement
hold
is very
anything in this
necessary.
matter, it would have anything. How can you make allegations that those persons are being given some benefit without making them a party?
Because when we filed this petition, even technical bid was not open. But in the second writ petition, we have made a statement, Millard, because LOA has not been issued.
No, in the first writ petition also.
Para 22, second petition, we have made a statement, Millard.
No, why have you enclosed?
No,
these-
we can complete them, Millard. There's no difficulty.
No, Mr. Chaudhary, you have enclosed all these documents, particularly from page,
In the first petition, from 228 onwards.
from 232 onwards.
Yes.
All this you have enclosed out there and making allegations against this Navaduga Engineering Company. Is he a
Millard,
party?
which
Is he a
one, Millard?
tenderer?
No. We have, as L1 is LNT and L2 is EPSCON.
AFCON.
Yes. No, perhaps, Millard, in today's context, they may be a necessary party that will implement. We are not on trying from that, we'll do that, Millard. And in the second writ petition in para 22, we made that statement.
Now, what is page 247 of the first writ petition?
Yes, Millard.
Some Aizol Bridge collapse. Who constructed?
1 second.
ABCI.
Mizoram, Millard.
Yes. Carried out by ABCI Infrastructure Private Limited.
That will give, Millard.
Then Visakhapatnam 2 held, NHAI forms so and so. That is against so and so. What is against L1? Where is the document?
Yes, that in the second writ petition, Millard, page number, I think, where is that financial part? 140, the financial thing. The undertaking? No, the financial thing. So L2, L1, L2 किया है. 1 second, Millard. Yes, page 127 of the second writ petition. My lord, Larsen and Tubro, 1,331 crore.
No. Where is the document that they have this problem? Their bridge have fallen.
Oh, in the first writ petition, my lord.
So therefore I'm saying in the first petition, you are making allegation without
No.
them a party.
Well, on that day, we didn't know that they were going to make them, L1 or L2. Milan, our idea was to project before this honorable court, if this criteria is applied, no major contractor can take part in this tender, Milan. That is why. Kindly see, all of them are there.
Show me where.
Page number 228, it starts, Milan. Kindly see. Sample news report regarding history of collapses having occurred in projects being undertaken by some of the major infrastructure companies in India.
Where?
Page 228, Miller,
228.
of the first writ petition. Kindly see on the right hand column, contractor, Larsen and Tubro, Abscon, Nagarjuna, Gemon, Navayuga, National Building, NBCC, ABCI, Dilip Buildicom Limited, Quandigo Construction, Oriental Structural.
So here number 3 is FCONS.
2, yes, 1 and 2, in fact, 1 and 3.
The 3 is FCON.
3 and 4 are Abscon, 1 and 2 are Larsen and Tubro.
And this 3 is 3 and 4. If FCON is there, then the FCON would be also disqualified.
Yes, yes.
So is it your challenge to that effect?
No, because when we filed this writ petition, we didn't know. That was, even then, technical bid was also not considered.
But as on date also, there is a new
No, no.
petition.
As on date, my lord, yes, in the second writ petition, after my lord, they have placed before this honorable court. Then we got to know that our technical bid has been rejected on account of 2 reasons. There, that's why in para 22 in the second writ petition, we have made that statement, my lord. Please come to the second writ petition. Para 22 at page 18. It is pertinent to mention that aforesaid statement of financial bid also makes it evident that L&T has been declared as L1 bidder for the said tender. However, to the best of the petitioner's knowledge, no third party right has been created in favor of L&T or any other entity with respect to the said tender, and therefore they are not being implemented in the present writ petition as yet. Petitioner reserves its right to implement any such third party in the present petition at a later point of time if required.
No. Where have you made the statement against L&T? As well as FCONS, because you say L&T and FCONS
Para
are
21. Para 21. That pertinently both L&T and EPSCON have had history of collapse of superstructure, substructure of a
in the
span
last
of
3 years.
yes.
Annex 14 of the present writ petition. Where
Yes.
is that? Where?
Yes. Annexure 14 is page 127. No. Sorry, 1 second. Lord, annexure 14 of the first petition, Miller. थोड़ा गलती हो गया. So we said, my lord, it has been selectively applied.
So that is your good case.
Yes.
Why you are not on that then?
Yes.
You are on the other aspects and without making them a party. You don't have a case for other things.
And my lord, the second ground, rejection on financial ground, that is
They
also.
may either change the term or have everybody,
Yes.
if that is so. Yes, what do you have the instructions for this? As regards L&T and FCONS?
L&T LOA already issued.
No, understood. It's not issued, but whether they had the mischief as regards.
No. So Lord Sir, kindly bear us page 228. 228 of the first petition.
What is the news item, Lordship? What they have relied, Lordship?
Yeah.
To wait, Lordship. Description part, pilot may kindly produce one. News article titled Baraka Express Nisab so and so suspended key personnel of LNT so and so. Then Madam number 2, news article of Chennai Metro Rail. /1 fine for contractor remove 4 staff after Rampuram guided crash loss. Then Lordship, Abscon concrete slab falls Lordship. Then article 4 Lordship, Abscon 2 workers killed in a cement grider collapse so and so. Then my lord may kindly come to page 1.
Accident averted. Concrete slab falls on Bhagalpur Bhirpur Bridge.
Milord will kindly come to page 230, Milord. That's the news item. Towards the bottom, National Highway Authority on Sunday said has suspended key personnel of developer Larsen and Toubro and supervision consultant so and so after a portion of an under construction elevated road on Dwarka's Expressway collapsed this morning.
But this is 2021.
Yes.
My lord may kindly come to.
That is why, Milord, 5 years was brought down to 3 years. Initially, it was 5 years. Then, Milord, at page 232. This is regarding.
Has slept the final on the for recent reader.
Then, Milord, 232 is of 2025. Which is the portion. Milord, at page 233.
No, this is not collapsing or anything to do with the bridge. This is some grider falling down.
Same thing, Milord.
No. Grider is different.
So fine, so Lordship, page 132.
No, Milord, grider and substructure both are involved, Milord.
Page 132, my lord may kindly introduce the conditions for page 132.
No, Milord, if you also kindly looks at that clause 2.2.244, it speaks of, Milord, superstructure, substructure, everything.
Page 132, Lordship.
Yes.
So Lordship, there should not be history of collapse of superstructures, left substructure of any span of beach, flyover, viaduct, metro link work during construction was. Service at least 5 years, that part already 3 years it was done, Lordship. It was come to Lordship, page 99, Lordship, new 99, page 99. There's, Lordship got it?
You made it 3 years.
Lordship, it was made 3 years. And also regarding explanation part, is submitted that there was no explanation. That is also there, page 148, Lordship. Verification part is there, to PB with you, Lordship. 148. All bidders are participated, even petitioners also participated in the previous meeting.
48, yes.
148, Lordship, serial number 22, extreme right, Lordship. The clarification.
Addition of so and so or modification that there should be a history of so and so. Iman for the last Iman years, 3 years, ending last day of the year. Has been incorporated to revise there the collapse so and so year.
The clarification part is there. The clarification has been incorporated in the revised RFP. The collapse of superstructure, substructure pertain to design, failure or quality related to failure of permanent structure would be considered in the clause.
Design failure or quality related failure of permanent structure would be considered in this clause. So this is the explanation.
It is the explanation. It is not a case that railway has not explained it, Lordship. And
No,
then may kindly come to.
Sorry, Milord, one second, Milord. Ours is not a permanent structure, it's an ongoing project. Ours is not a permanent structure, it's an ongoing project. There's a difference between a permanent, that means once it is completed. During the course of construction, if something happens, it's an ongoing project. They are speaking of, Milord, permanent structure. Ours is not a permanent structure, it was an ongoing project.
My lord, then kindly come to lordship page 200 lordship. 200 lordship, Patna High Court for particular document. First paragraph lordship. All the above writ petition arises from the
When
incident.
did you construct complete the construction?
It's not.
Or is it
It's,
still going?
it's not completed as yet, my lord. It's going on.
Okay, show me your tender conditions, tender terms earlier. Notice inviting tender of this.
Of that Patna work, of that Patna.
Then we'll come to know whether it was completed or not.
When lordship revised RPA is page 99.
We can bring current status, my lord. Current status of construction. And including the
current
NIT,
status, the
including
earlier
the RFP.
construction, because you are saying that it was being constructed only to that effect only, huh?
Yes, no, it was an ongoing project, we said, my lord. When we say permanent structure means, my lord, the project is complete, handed over.
Also,
When
the
the-
RFP lordship page 99 lordship. There
Yes.
should not be history of collapse, superstructure, substructure, any span of bridge, flyover, viaduct, metro link, walk during
Anyway,
construction,
what is the
less
clause is
service
page
in last 3 years.
That is not the one.
During construction, less service in last 3 years, 10%. It is there. It is admitted fact that lordship, the key span of pillar was, structure was fall down in the Bhagalpur beach lordship. Admitted fact. Then and this condition is applicable for all lordship. For applying this, applying these conditions, other eligible bidders, if lordship that part we have lordship delete today for a moment. Lordship. Other eligible bidders are not participated, KNP not participated. One of the lordship famous infrastructure lordship builder, KNP not participated. That is Malayapuram not participated. Only that grounds. And it is not the law, even if lordship that condition we cannot put it. And financial conditions we cannot put it. If it treated as a lordship debarred, we should treat it as a blacklisting. Then financial condition 5% of the amount lordship. Then other persons also lordship cannot. Then no, then tender authority cannot put a single lordship conditions in the tender document. If that be so. Either that way or this way, some will be lordship not uneligible lordship, unqualified lordship.
My lord, therefore, our submission is, my lord, as far as this first condition is concerned, this is clearly, my lord, arbitrary. And regarding the second one, my lord, regarding the financial capability, they have not even considered the implication of clause 2.2.7, where it says that we must give an undertaking and last previous 5 years financial statement should be given, which we give.
So if you cannot give it in respect to the latest financial year,
Yes. Then we can give for the last 5 years preceding that. And
No,
we are
no,
supposed
no,
to give an undertaking.
no. Kindly come to
Yes,
2.2.7,
1 second, 2 point at page 93.
page 101. Okay.
No, my lord, page 93. Roman 2. In case annual account has a lordship got it, my lord. Page 93 of the second petition.
New one.
Yes. At page 93 towards the bottom of the page. In case the annual accounts of the latest financial year are not audited and therefore the bidder cannot make it available, bidder shall give an undertaking to this effect and statutory auditor shall certify the same. In such a case, bidder shall provide audited annual reports for 5 years preceding the year for which the audited annual report is not being provided. I may just inform your lordship, my lord, the requirement is 75 crore For the current year, we have, my lord, 1330 crores net worth. And for that particular year, 24-25, we had 1124. And because it was submitted on 27-8-25, therefore, my lord, our financial statements were not ready because following audit and all, we are supposed to
So
submit
what
it.
did you submit?
Yes, that undertaking is there, my lord. Undertaking is dated 22-8-25 at page 115. We hereby give an undertaking to this effect that annual accounts for the latest financial year 24-20 have not so far been audited and hence the same cannot be made available with this application. Then, my lord, at page number 118, my lord. This is of course dated 6-10-2025 for the 24-25. Our net worth is, my lord, 1339 crores. It is dated 6th of October 25. And page 113, my lord, the one we submitted. It was 1124 for 23-24.
So you submitted the audited accounts for this 2023-24, 2022-23, all these.
Yes,
2019?
yes, all 5 years we have given.
You have submitted?
Yes, it will be evident from the financial bill.
Yes, reply. So this you have submitted.
Yes, yes. So, my lord, therefore, both the grounds of rejection of my technical bid are arbitrary, my lord.
Okay. Anything more, Mr.
That's,
Chairman?
my lord, subject to what my learned friend says.
So my lord, the RFP starts from here, Rosi, in second petition, Rosi, starts from page 69, Rosi.
Okay.
Page 69, RFP starts from Rosi. Page 69. So my lord, may I kindly come to page 72, Rosi.
Yeah.
Page 72, Rosi. Rosi, got it? Page 72, Rosi, got it? Page 70, last two paragraph, Rosi. Rosi, I can read it, Rosi. The completed bid document can be viewed as downloaded from official portal of the railway website so and so on 23/5/2005 to 27/08/2025 up to so and so. The bidder must submit its financial bid and technical bid so and so on or before 27/8/2025. My lord, may I kindly mark that part closely. 27/8/2025 closely. The bidder has to submit the bid, lordship, on or before that particular date, lordship. So, lordship, my simple submission is that, lordship, the bid RFP should be read as a whole, lordship, not one stanza or another thing, as a whole. So, my lord,
Tender notice was issued on 19/9/2025.
lordship, and it should be filed, lordship, on or before 27/8/25. That is very important, lordship, regarding that particular issue, lordship.
Yes.
Then lordship, kindly come to page 86, lordship. 86, lordship.
Okay.
2.1.13, lordship.
Yes.
Notwithstanding anything to the contrary content herein, in the event that the bid due date falls within 3 months of the closing of the latest financial completed year, my lord, may kindly mark it. My lord, may kindly mark that particular two sentences, lordship. Notwithstanding anything to the contrary content herein, in the event the bid due date falls within 3 months after closing of the latest financial completed year of the bidder, it shall ignore such financial year for the purpose of its bids and furnish all its information and clarification certification with reference to the 5 years or 1 year as the case may be so and so, so and so, so and so. Meaning thereby
Meaning its latest financial.
24, 25 lordship. 24, 25. Bid was issued lordship. Bid was issued on June lordship. The latest financial year that was done on 24, 25 lordship. Now it starts from 25, 26 lordship. Financial year. 25, 26 financial year is going on lordship. For financial year part, my lord may Section 241 of the Companies Act lordship, that part. The Companies Act. Companies Act. If lordship,
No, why do you need to go into the Companies Act when it says
lordship,
for avoidance of doubt, financial year shall for the purpose of a bid hereinunder mean the accounting year followed by a bidder in the course of its normal business.
lordship. That is 2024-25 lordship. If lordship, the bid documents have to submit it after March 31, within 3 months period, March, April, May, June lordship. Then he have to submit lordship that latest file. By excluding the latest financial year, they have to submit the preceding financial year portion.
So now it is not 25, 26, you have to say about 24,
24,
25.
25.
So they have to submit till 2023, 24.
23, 24 submit, subject to conditions that if it is fall within the 3 months from the latest financial year. That is the latest financial year was expired on lordship 31st March 2025 lordship. From the closing of the latest financial year period lordship.
So therefore it says that
Lordship.
if you are to submit
Lordship,
on or before 30th of June 2025,
lordship,
then in that regard you forget about 2024.
lordship, lordship.
They are saying,
Lordship.
but the fact remains, if it is beyond that, but the financial statement is not audited, then you cannot submit here.
Other persons have submitted, other bidders have submitted lordship.
Maybe somebody has not
Other
happened,
bidders
but you
submit-
have given the exception to that.
That exception, even lordship, the annexer T also, annexer T which was submitted, they have not enclosed the whole document. I there's the annexer T also. Annexer T, their clause is also there.
Page 113.
113 lordship, they have only submitted the statement part. lordship. The instruction part is not there lordship. Instruction parts, my lord may instruction starts from 1, then my lord may kindly come to instruction
Shall
number 4.
attach copies of the balance sheet, financial statement, annual reports for 5 years preceding the bid due date. The financial statement shall reflect the financial situation of the bidder and associates where the bidder is relying on its associate. Be audited by the secretariat. Be completed including all notes there. Correspond to the accounting period on the audited. No statement partial. Then
Clause 4 lordship. Clause 4 reiterated the provision which was lordship reflected in lordship 2.1.13 lordship.
this is okay, but then how do you take care of this particular clause?
Lordship.
It categorically mandates that page 100 and what you call page 1.2.7 or what it is.
That's why I'm saying, Lordship, that tender documents should be read as a whole, Lordship. When annexers which was incorporated in respect of that particular point, the annexers also, Lordship, reflected that point, Lordship.
Where is the clause gone again?
Page 93, Milord, 2.2.2.7.
Here it categorically say if in case the annual, because you see, in your document which you have just submitted,
Lordship.
one, the bidder shall attach copies of the balance sheet, financial statements and annual report for 5 years preceding the bid due. The financial statements shall come to D.
Lordship.
First, be audited by statutory auditor. D corresponds to the accounting period already completed
Lordship.
and audited. No statement for partial period shall be accepted. So it has to be audited.
It has to be audited. One stipulation is there, Lordship. If tender document is to be submitted, Lordship, bid document is to submitted within the period of 3 months of the last financial year, Lordship,
Then you have to give up the earlier one.
then have to give up the
No, but how do you take care of 2.2.7 Roman 2?
2.2.72, Lordship.
In
We have
case the annual account for the latest financial year are not audited
Lordship, Lordship.
and therefore the bidder cannot make it available. The
Lordship.
bidder shall give an undertaking to that effect and the statutory auditor shall certify the same.
Lordship.
So this is the certificate which is
This
being
is
given.
there, Lordship. This is there.
In such a case, the bidder shall provide the audited annual report for 5 years preceding the year for which the audited annual report is not being provided.
That is there. So, Lordship, that particular clause we have to read conjointly of 2.1.1.3 and Lordship the annexers which has to given by the Lordship contractor as per 2.2.72, Lordship. Annexer itself says, Lordship. The undertaking annexers which was the prescribed format given by the railway in the that RFP, Lordship, which relates to, Lordship, 2.2.2.7 Roman 2, Lordship. It is specifically stated in clause 4, Lordship. That is there, Lordship. The annexer itself, Lordship.
And why did you reject in terms of 2.1 that breaking of the bridge construction clause? Why did you reject? What is your ground given?
He has not furnished the undertaking, Lordship.
That's the ground, nah?
He is not furnished the undertaking, Lordship. He has not furnished the undertaking, Lordship. He has not furnished, even our affidavit also, we have said so, Lordship.
No, I've looked into your affidavit. That is no problem. That affidavit I've looked into. You say that the majority of the thing is that you have done it.
Lordship.
Obviously, you being the author, you can very well do it.
Lordship.
Therefore, my only problem which I could see in Mr. Chaudhary's case is he has not furnished the undertaking.
He has never furnished, Lordship. Never furnished the undertaking regarding there is no collapse of the bridge, Lordship. At no point of time he has furnished undertaking. The undertaking which was furnished is before, Lordship. LOA is already issued on 6th, Lordship. I have the copy also, Lordship. LOA copy also there.
Letter of acceptance.
Letter of acceptance is issued.
Sixth, much prior to this repetition being
Then-
filed.
Yeah. Lordship, after they have referred a miscase in the earlier cases, Lordship, regarding stay for the issuing of LOA, Lordship. That was rejected by the Honorable Court. Accordingly, we have proceeded, Lordship. We have issued it. And miscase order is also there, Lordship.
Miscase quota say.
Miscase itself there in the order, Lordship. People legal order.
Wow, very long order. Oh, no, forgot.
After Lordship, financial with Lordship, they have approached this court for restraining or Lordship, issuance of the LOA, Lordship. Then Honorable Court considered it and rejected their Lordship contention, Lordship.
Mr. Chaudhary, you have not challenged this order,
Which one, my lord?
3110. Passed in the IA.
Order dated 31/10. No, my lord, that is again subject to outcome of the main writ petition.
Understood, but
Yes.
here, with this order being there, how can I stay now?
My lord, all that we are saying, no, my lord, idea was perhaps, no, that's why we prayed that both the writ petitions should be taken up.
Understood.
Lords will finally
So
take a call.
Therefore,
Huh.
the thing is,
No, because in that order, my lord, the learned coordinate bench also notes the earlier order which says whatever they do will be subject to the outcome of the case.
understood,
Huh.
that is okay. But the whatever remains.
No, with that understanding, my lord,
Not stay.
no,
Court say that you go ahead.
no, that's what, my lord. All that I'm saying is, that's why the idea was, we mentioned the other matter also, so that lordship takes finally a call.
Because here he says,
Ah.
one.
No, that is, lordship is correct, my lord. That position we are not disputing.
That is again a difficult position. You have another means. If I just think of giving some order also, everywhere I'm being caught, although I'm not agreeing with his financial question. Financial question I'm not agreeing. But otherwise, this order makes it very difficult again.
No, my lord,
For
therefore,
passing an interim order.
therefore,
And Mr. Chaudhary, whatever may be, you are not such a thing. You should have asked the people why they have not made this other 2% a party. You
No,
know that the LOA has been issued. It is not that.
no,
they don't
LOA
know.
part today only what to know, my lord.
Are you not aware that?
No, yeah, there was no occasion also.
Filed a writ petition.
When they approached by way of miscast lordship, it is their knowledge that who are the successful bidders. As per the EXCOM lordship.
Why
paragraph
you
18
have not issued them?
No, my lord, on that day, this statement was not made that they have issued. That's why we made the statement, no third party right has been created.
On that day itself, they have the full knowledge.
And 6/11 was yesterday.
6/11 last year,
Yesterday.
And it was, the process was done after lordship, the miscast was lordship rejected by the.
Anyway, my lord, this is a project which will take a lot of time. It's not that tomorrow they will start, within 1 month, the project will be over. So, my lord, that's why we made a mention of both the matters, so the lordship takes a call finally. And they have filed their affidavit also, my lord.
And it's a project of national.
But whatever may be, you are saying anything, you need to
No, my lord.
make those two people a party.
Today, my lord, that we have come to know that LOA has been, definitely will make them a party.
Not only LOA, you are making allegations against two. One is F1 and the other is so and so. These are the two who have been technically qualified. So isn't it necessary for you to make them a party?
No, that is correct, my lord.
After making allegations, I would have said, okay, the allegation is not there, allegation is only against them. But you have allegation that for them, this clause is not applied, for you, this clause is applied. Without that, how do you proceed? Very difficult.
Not only that, even during that particular 3 years period, particular 3 years period which was we targeted, KNP, Malaypuram, and other 3 major lordship contractor has that particular history also. They have not participated because that particular clause is there.
My lord, most interestingly, this 2.2.2.2, in other work, I have been adjusted as L3. In respect of another work, my lord, where I gave a similar undertaking regarding that financial part. Railways have considered my bid, but unfortunately, I came out L3. My lord, in that case, my lord, we will make them a party very shortly. Monday itself, we will file the petition. According to
Then
lordship's convenience.
why don't you withdraw this petition and file a fresh one by Monday? I'll take it up again with this matter on Tuesday.
Second one, my lord. Second one.
I take up the first matter on Tuesday. Give you the liberty to, in view of the, I'll say that in view of he saying that the LOA has been issued, you are going to make them a party and all. And therefore you withdraw with liberty to file again, and thereby you file it, we take it up on Tuesday.
Tuesday could be Wednesday.
Because otherwise, you see, the ogling eyes of all your learned friends out here.
Thank you.
So therefore, you need to, in view of this, you come up with a fresh petition And withdraw this.
Make
one
them
and
parties and I'll
make
also
them a
impugn this
party.
order.
And if you have allegation against AFCONS also, make them a party to the
Yes, yes.
effect. And make it better, do not with this.
We'll
thing
do that,
that-
we'll do
and
that.
so we take up this matter on Wednesday.
Wednesday.
We have it on Wednesday.
नया वाला मंडे को एकदम फाइल कर देना
Mr. K. Goi, the learned counsel appearing on behalf of the respondent, submits that the LOA, letter of acceptance, have been issued in favor of a bidder, namely S. Larson and Kubor Limited, Faridabad, on 6/11/2025. Mr. K. N. Chaudhary, the learned senior counsel, assisted by so-and-so, upon instruction, submits that the petitioner would be well advised to withdraw the instant writ petition and not only challenge the rejection of the petitioner, but also not only agitate the cause of action in the present writ petition, but also challenge the impugned letter of acceptance. So taking into account, he therefore submits, withdraw the writ petition.
Second one,
Taking
Milord,
into
6
account
to-
the above, the instant writ petition therefore stands closed, with liberty given to the petitioner to assail, again assail the impugned actions which were the subject matter of the present writ petition, as well as the letter of acceptance. A copy of the letter of acceptance has also been provided to Mr. So-and-so, the learned counsel, who assists Mr. K. N. Chaudhary, the learned senior counsel. Petition conduct. This court have heard the learned counsels appearing on behalf of the petitioner, Mr. K. N. Chaudhary, heard Mr. K. N. Chaudhary, the learned senior counsel, appearing on behalf of the petitioner, and Mr. K. Gogoi, the learned counsel, appearing on behalf of the respondents. Taking into account that further hearing would be required in the instant proceedings, this court fixes this matter again again on you want on 12th, no?
Yes.
On 12th November 2025.
Deeply alert.
In the meantime, you filed that, huh?
Yes, Milord, we'll file it by Monday.
But this IA order is very dangerous for you.
Yes, yes.
He has dealt with many aspects. It becomes very difficult for another court to influence.
That is why, Milord, I mentioned this matter so that it can be finally taken a call. Anyway, Milord, we have taken note of what has fallen through, Milord.
Consideration part was also Lordship. That part considered. Whether it was considered or not, that part also was discussed and considered in this.
Anyway, that is why I asked him whether it changed. Anyway, let us see.
Okay, deeply alert.
Oh, bhai dibo, huh?
My lord, this pertains to a construction contract in the Guwahati railway station, my lord. Some additional.
What contract?
A construction contract for additional amenities in the Guwahati railway station, my lord.
Additional?
Amenities, my lord. Some additional rooms, facilities, etc.
Never
to be
happened.
constructed, my lord.
You are challenging it.
No, my lord. The LOA was issued, my lord, on 25th of November 2024, in my favor. But until May, my lord, I was not handed over any site or my lord drawings, etc. So when I write to them, my lord, they said that your progress of work is slow.
Huh?
They replied back by saying that your progress of work is slow. So therefore, my lord, a contentious issue came in that whether, my lord,
Well, what do they write? I don't get it.
my lord, they write that my progress of work is slow, my lord.
Oh, okay.
And
On
then
the other hand, your stand is that they have not yet handed over.
they have not attended over, and
Show me
therefore,
where
my
you-
lord, I applied that, I asked that as per the contract condition 62 clause, there has to be a dispute adjudication board appointed by them within 90 days of signing of the contract. Even after that communication, my lord, that has not been appointed till date. So therefore, my lord, I am before your lordship. That particular clause, lordship, would-
Where is the communication?
my communication, my lord, would see at page 33. Page 33 is part of my lord annexer 5. Page 33.
This you have written.
My lord, this we have present,
Letter of acceptance issued on 25/11.
my lord,
Then they write that the progress is slow.
my lord.
Then you say that there is nothing done.
Nothing done, my lord. The
Then
site
what
and
do-
drawing, even till today, my lord, only 10% of the work front is
We have
available.
deposit, huh?
Only
We have
10% work front is
deposited the
available.
bank guarantee along with the work order for performance plan of the contract, not for waiting the contract for last 7 months or year. Now, what do you want?
My lord, I want that, I had been requesting that you appoint the dispute adjudication board as
Immediately
per the
issue
contract.
further scope of work along with the drawings and site free from obstacles, keeping in mind the project cost is 53 crores and not 2-3 lakh. Since we are left with no other work to be carried out on site.
Well, in this case, for a 7 days notice has been issued due to poor performance, and now 48 hours notice has been issued. That is issued before the authorities are contemplating to terminate the contract due to poor performance of the contractor. Now, that subsequently they have represented for reviewing that 48-hour notice as they want to perform the contract. Now, that is under consideration by the authorities, because this contract is worth.
But did you hand over the site? He is saying that no response, status till date, no
These
response.
are not correct.
Labor idle, sitting idle.
These are not correct, these are not correct facts,
What is correct fact?
In fact, lastly on Lordship would page 62, on 18/10/2025 also we indicate that so many other drawings and etc. are not to be handed over.
Contract, because it will again cost, railways.
What I understand, my lord, because it's a functional railway station, to hand over site and portions there is difficult. Because it's a functional and ongoing railway stations.
We are not-
So there are, of course, hindrances. But then it has to be, my lord, sorted out. Therefore, a adjudication board is there as per the contract. Let them.
So you are asking that this court should constitute a dispute adjudication board,
My lord,
as per Swen.
my lord,
Yes.
as per clause 63,
But
2.1.
Adjudication of dispute board will not bind any parties not to perform the contract. The
Yes, yes,
performance
definitely,
of the contract must go on.
definitely. Even if there is a arbitration, the performance of the contract, unless terminated. it
No,
has to
did
go on.
you ask for that?
Yes, my lord, we asked, my lord, page 33,
Where is the term of 63.2?
my lord, that is at 171, page 171.
First line says any dispute is not settled with the engineer.
Yes.
Shall be. Yeah.
engineer please. As per the wording of the contract, even if I don't ask for a dispute, my lord, this board has to exist within 90 days, my lord, of the agreement.
Hmm?
This board has to exist, my lord, within 90 days of signing of the agreement itself.
Of the?
Signing of the agreement, my lord. So that is how it is worded. The DAB shall be formed within 90 days of signing of the contract agreement. So that anything that comes up in the contract can be sent to that board and it's.
So you are saying above 50 crore.
It is above 50 crores. It's 52 crores, my lord. So therefore, no conciliation.
So contract is signed.
Contract signed, my lord.
Then why you are not referring? Refer.
It's comprising of their officials only, my lord.
It is, you act as per 63. Do whatever, but for that, the work would not stop.
My lord, definitely.
Or any action. So this dispute adjudication board will decide.
Yes.
His only plan is that.
My lord.
So let us dispose it of.
Yes.
Huh?
My lord.
Heard Mr. B. Pathak, the learned counsel appearing on behalf of the petitioner, Mr. H. Gupta appearing on behalf of the respondent. It is relevant. The petitioner herein had sought for a direction upon the respondents to constitute the dispute adjudication board as per clause 63.2 of the standard general conditions of the contract governing the LOA number 00911210117832 dated 25/11/2024. Pusto. And now tell me whether the contract agreement has been signed,
My lord, it has been signed thereafter, my lord.
whether it has been signed or not.
Yes, my lord.
When?
The date, my lord, I don't have.
No, because that is the thing now within 90 days of signing the contract.
Definitely, it was definitely signed, my lord, therefore.
Oh,
we could
get
proceed.
instruction, list the matter again on Monday, on which date Mr. B. Pathak shall obtain instruction as to whether the contract agreement has been signed and when. My goodness, that is your basic case.
My lord,
And you are pointing out a particular clause where it says within 90 days it has been constituted, but from when you don't say. Okay.
initially there was some delay, my lord. Initially there was some delay,
Monday, Wednesday.
my lord. I'll get the copy, my lord.
Not on
Monday.
that, I'm only asking you, you want the DAB,
My
and
lord.
pass an order for the DAB, but you have to mention whether it is 90 days. If it has not yet been signed, how do I direct?
My lord. Definitely signed, my
Wednesday.
lord, without which the work would not have progressed also.
Oh, you never know.
Item 59.
My lords, I'm appearing in item 59 virtually. I, at the outset, apologize for not being present physically, my lords.
Yes, what is it?
My lords, this is a writ petition. I appear for the writ petitioner who was declared L3 at the end of the financial round. The respondent number 1 is the tender issuing authority, PWD. Respondent number 3 is L1 and respondent number 4 is L2. My lords, the contract basically involved construction of a circuit house in Udalguri district. The NIT, which my lords will find at page 24, is dated 29th of July, 2025. Just to give you a very quick background before what my case and submission today before your lordships is, the total amount mentioned in the NIT is roughly approximately about 13 crores.
So you are challenging the selection of
Yes.
respondent number.
I am challenging, my lords, I am challenging the declaration of L1 and L2. It is my case that both L1 and L2 during submission of their bids have violated the commitments that they themselves have given under the tender agreement to the authority. And for reasons best known to the authority, these violations appear to have been endorsed by the department. I would just like to take my lords to the relevant clause, which according to us gets violated. And then I would like to take your lordships to 4 pages to demonstrate this violation. If my lords will have page number 47 of the paper book.
Yes.
My lords, at 47, my lords will see an integrity agreement. Every tenderer essentially had to sign this agreement as a part of the tender document. At page, my lords, I'm sorry, it's page 47, not 74. I'm really sorry, my lords. Page 47. Does my lords have page 47? Yes. If I'm reading right above Article 1. And whereas to meet the purpose aforesaid, both the parties have agreed to enter into this integrity agreement, the terms and conditions of which also shall be read as integral part of the tender document. Now, I am alleging violation.
Which clause you are reading?
I am going to now read clause.
No, which clause you are reading?
I had just read the paragraph above Article 1 at page 47, which basically says that the integrity agreement is a part of the tender document. Essentially, my lords, every bidder during submission of the bid had to sign this integrity agreement. This integrity agreement is basically a representation of commitments that every bidder gives to not indulge in any fraud, to not indulge in any fraud, corrupt practice. Now, I am alleging violation of Article 2(2)(b) at page 48. 2(2)(b) at page 48. Article 2, that is titled Commitment of Bidders/Contractors.
Not enter with other bidders in any undisclosed agreement or understanding, whether formal or informal. This applies in particular to prices, specification, certification, subsidiary contract, submission, or non-submission of bids or any other action to restrict competitive or to cartelize the bidding process.
Right. My lords may just keep the word certification in mind. The objective of the tender document is very clear that two bidders cannot come together at any point of time. In fact, the bid specifically prohibits joint ventures for this particular purpose. What has happened, my lords, is L1 and L2 have done the site inspection together. They have sent their representatives together to the site inspection. The site inspection has happened on the same date. To demonstrate this, I would like to take my lords to 4 pages. So L1's bid starts at page 51.
Where is the site visit certificate?
The site visits, yes, my lords, I'm very grateful for the site visit certificate for L1, my lords will find at page 58.
Yeah.
Now, this certificate is dated 14th of August 2025. This certificate, as my lords will see, is signed by the PWD department. It says, this is to certify that Shri Biplab Doimari, representative of Allied Construction, which is respondent number 3, has visited the site along with an assistant engineer for the work of construction. My lords may kindly see the next page. The photograph is extremely important. My entire case is based on this photograph and the next photograph. At page 59 is the photograph submitted by respondent number 3. My lords will just take a look at these two individuals. My lords will see that this photograph was taken on the 8th of August 2025 at 4:32 p.m. Now, my lords will come to page 69. 69 is the photograph that has been annexed by Pooja Associates, respondent number 4. Identical photograph. The persons that my lords had seen at page 59 are the exact same persons that my lords will see at page 69.
Is the same person?
The same persons.
Huh?
The same persons.
Isn't it a different person or same person? Same person.
Same persons. Two bidders who are not required to come together under the contract for any purpose have gone to the site together, carried out the site inspection together, clicked a photograph at the same place at the same time. 14:32, 16:32 is the time indicated in both the photographs.
No. It is the same person.
Yes, my lords, that is my
How
contention.
do you say that this photograph has anything to construction? This photograph is the person in respect to this person?
My lords, page 58 is the photograph annexed by respondent number 3.
No, page 59 and
Right.
page 69
Right.
are photographs of the same persons, both.
Correct. Right.
So, but how do you say that page 69 is for respondent number 4 and page 59
Because
is respondent number 3?
I should have made this clear. Page 69 is a part of the bid submitted by respondent number 4, and page 59 is a part of the bid submitted by respondent number 3. These two pages are essentially parts of the integrity agreements that both respondent number
Okay,
3.
no problem.
Lordship, from the meetings, whether the requirement of the photo along with the site visit certificate.
Are you going to say that?
No,
Be careful, Mr. Chaudhary. Mr. Chaudhary, if you say that, there's no problem. I'll record it. But the fact remains, if this is the photograph which have been enclosed out there with geotech location, with the assistant engineer, and this is the photograph we take it. No problem. Photograph is not required. But later on, you cannot insist. It has to be the stand of the PWD.
Because the tender document that has been in it, it's not complete document, Lordship.
My lords, if I may.
have to verify it. from
Okay,
the-
we stay it in the meantime.
Yes.
Lordship, may allow me
Yes.
till Wednesday, Lordship. I will get
Till
that.
Wednesday stay. Let me feel happy that in 2 cases I've stayed in the whole day.
I am so obliged, my lords. I am really obliged. The only reason I wanted to press for a stay today is because L1 has been declared and the contract may be awarded any moment.
Under number 3 or 4, or 3 or the engineer, or whatever.
No,
that's-
both the
that's-
persons are same.
Both the persons are same. There is no.
So
doubt.
therefore, his allegation is that both the person, one person was the representative of both the respondent number 3 and 4. That is his submission.
My lords, there is one more incongruency. If you see the certificates, apart from what my lords have, what has fallen from my lords, it becomes even more difficult to reconcile the situation when my lords will see the certificates which have been certified, endorsed by the department. That those documents refer to one individual as Digonta Borua. So if the certificates are to go by, then Digonta Borua has to be a part of both the photographs. And the Dolmaris have to be different. They have to look different. They can't be the same people. So there is incongruency also from the department, which is why it is our submission that this is a clear violation of the integrity agreement the bidders had signed. And for reasons best known to the department has endorsed this.
Wait. Mr. Chaudhary will take care of it. Issue notice, when do you get your instruction?
Monday.
So early.
Yeah.
Issue notice making it returnable on today, Friday, but I'm staying it.
Otherwise, my lords, the contract will be awarded. The writ petition becomes infructuous.
Order is yet to be issued.
Okay,
That
issue
Lordship,
notice making it
Monday.
no, okay.
Till Monday, Lordship, I can issue it.
No, but I can also assure you I'm passing a stay order. Okay, I won't issue as regard 3 and 4 now. You want a Monday, we give it to you on Monday. Issue notice making it returnable on 17th of, on 10th of November 2025. Full stop. Issue notice only upon respond number 1 and 2. Returnable on 10th of November 2025. For the present, this court is not inclined to issue the notice upon the respondent number 4. Taking into account that Mr. B. Chaudhary, the learned standing counsel appearing on behalf of the PWD, submits that he can obtain the necessary instructions by Monday. That is 10 so and so. This court shall consider issuance of notice upon the respondent number 3 and 4 on the next date. The case of the petitioner herein is that the petitioner, along with various other bidders, submitted bids for, in pursuance to, a notice inviting tender issued by the PWD department, issued by the
Office of the Chief Engineer PWD Buildings, my lords, respondent number 1.
by the Chief Engineer PWD, Chief Engineer Building PW bracket BNNH Department Chanmari for construction of the new circuit house at Udalguri, Assam. Mr. R. Chaudhary, appearing on behalf of the petitioner, submits that in terms with the integrity agreement, which is a integral part of the tender document, and more particularly Article 2, bracket 2, small b, it is required.
My lords, 2.2.b, my lords.
2 bracket 2
B. Yes, correct.
of the more particularly Article 2 bracket 2b. The bidders of the contractors could not have entered with other bidders in any undisclosed agreement or understanding, whether formal or informal. The learned counsel further submits that this aspect also applies to prices, specifications, certifications, subsidiary contracts, submissions or non-submissions of bids, or any other actions to restrict competitiveness or to cartelize in the bidding process. The learned counsel further submits that both the respondent number 4, 3 and 4 submitted along with their bids the site verification certificate with photographs having geotag locations In the bid so submitted, page 59 is respond number 4.
Yes, my lords.
In the bid so submitted by the respondent number 4, he had enclosed the documents which have been enclosed at page 58 and 59 of the writ petition.
Sorry, my
And the
lords.
bids
Sorry, my
were
lords.
submitted by the respondent number 3.
My lords, respondent
The
number
site
3.
verification certificate had been issued, which is enclosed along with the photographs have been in the site verification certificate and the photographs so enclosed is at page 68 and 69. The learned counsel therefore submits that it is the same person who have represented on behalf of the respondent number 3 and 4. And as such, who have carried out the site verification for each other. Under such circumstances, in view of the integrity pact, which promotes in non-cartelization amongst the bidders, the respondents 3 and 4 having violated the terms, have violated the integrity pact, that bid of both the respondents ought to have been rejected. Full stop. This court directs, Mr. B. Chaudhary submits that he would produce the records of the bid documents on Monday. And accordingly, this court therefore fixes this matter on Monday, that is 10/11/2025, wherein the learned counsel, standing counsel for the PWD shall produce the records. Till the next date, there shall be no issuance of any letter of intent or any contract entered into with any of the parties in respect to the construction of the new circuit house at Udalguri on the basis of the notice inviting tender dated, what is the date? 27/7/2025.
29th/7/2025, my lords.
Lordship, page number 58 and 59 is of respondent number 3, Lordship, and 68 and 69 respondent number 4, Lord.
Much obliged, your lordships. Thank you so much, your lordships.
You want it on Wednesday? I don't leave it. Don't leave it to me, because you have to produce the records from where? Udalguri. So tomorrow is Saturday, day after is Sunday. Can you produce it on Monday?
Lordship, then take it up on Tuesday.
Not Tuesday. No Tuesday business. Wednesday. Wednesday.
Obliged, my lords.
Huh?
Thank you.
Yes.
I
Your
think
case,
it's on
that
item
case,
8.
which is to be dismissed. You again file. Who is appearing for this contempt matter? Yes. What type of case you have filed? Can the executive, you appear for the water resource department. If you initiate a contempt proceedings against the executive engineer, can the executive engineer make the payment? Tell me, who has to make the payment? The chief engineer. But you have not issued notice to them. You have not issued notice. You have only issued notice on that particular person, the executive engineer, on 2/2/2024. Then withdraw, file, take steps in terms with the judgment. The learned counsel appearing on behalf of the petitioner submits that she may be permitted to withdraw the instant contempt application and take fresh steps upon all the respondents for the compliance of the order dated 19/2/2024 passed in WPC number 630/2023. Taking into account the above, the instant contempt application stands closed. So it is observed that if the petitioner duly takes steps and there is no compliance, the petitioner would be at liberty to approach this court. Yes, where is it? Mr. EMD? Come. What is your case?
My lord, we have filed for the extension of time for deposit of the coal value amount, which is 13.60 CR, my lord. We
Huh?
have participated in coal auction
Ah.
through which we have been allocated 9,050 tons of coal. And for that, we were granted 10 days time to deposit the coal value amount, which comes around 14 CR, my lord, around 14 CR, including the upgradation amount. We have already deposited the EMD amount and coal upgradation amount of 1.9 CR, my lord. That 15 days got expired, 10 days got expired on 5th of November, my lord. But as per clause 5.3, my lord, as page number 39, my lord. The successful bidder, my lord.
Hmm.
This is coal policy, my lord,
Will
2022
be
on the
required
basis
to
of that.
deposit the coal value with the concerned area within a period of 10 working days after the date of closing of the e-auction. 10 working will be reckoned as the date to the respective so and so, where the payment of is required to be made. Yes.
10 working days, my lord. From
10 working-
25th of October to 5th of November, my lord, there were 6 holidays, government holidays, my lord.
What holiday?
Government holidays, my lord. On 5th of that, banks were closed, my lord. I couldn't have made even 50% of the payment, my lord. I have already written a representation to the northern eastern coalfield, my lord, to
When we-
done with the extension.
To deposit.
Or before or on 5th of November 2025, my lord. Before or on 5th of November 2025, my lord.
Ah.
That was a bank holiday, government holiday, my lord. I have written a representation on 4th of November to the respondent to at least grant 7 days more, or at least grant me 10 days working days. That is 6 days are left.
How?
My lord, from
No,
22nd,
give me, for this court to exercise the power, how do I do it?
my lord.
No, I don't believe, Mr. Counsel, I don't believe in mercy.
I
don't have
mentioned-
mercy.
I mentioned, my lord.
Mercy is there outside.
Right.
You should have had the matter on Monday and prepared it properly. Prepared.
No, no, ma'am. I'm so
No,
sorry, but I have
prepared,
mentioned in my
but
synopsis,
quickly
my
put
lord.
Your papers.
In my synopsis, my lord, I have mentioned 26th of October, that is Sunday. 27th and 28th, my area is closed due to Chhat Puja, my lord. I am a businessman from Jharkhand. And 2nd of November, my lord, there is
Where
Sunday.
is that particular place? The e-auction?
E-auction is on online. Online, Margarita, my lord, Margarita.
There Chhat Puja doesn't.
But in my area, banks were closed, my
So
lord. On the
therefore,
last date, banks were closed.
That can't help. You
I'm
are-
eager to pay, my lord. That
no.
is the reason I have written a representation.
So therefore, it's a mercy petition.
I am at
No, it's a
my
mercy
lord's
petition.
hand, my lord.
Isn't it?
No prejudice will be caused, my lord, to them.
What order has been passed? What is the
Nothing.
impugn order?
Nothing, my lord, nothing.
Nothing. You just approach this court for mercy, that this court shall extend it. That's it. Yes, Mr. MJ Ahmed. Don't you permit depositing with interest?
Go to certain guidelines that basis.
Huh?
We work on the basis of the policy of the policy.
They have submitted a representation.
That also last fifth.
On 4th of November.
Where is the synopsis?
The representation is
Where is your list of dates? List of dates is where?
my lord at page number 6.
E-auction 17/2000, Office of the AI Area Office issued notification announcing conduct of Iman of so-and-so of Iman, tons of Iman, the online. So 10 days will expire from 10 days, normally 27th.
25th, from 25th of October to.
Why 25th?
Because allocation was awarded on
On
25th of October.
23rd, Iman was duly released by the committee indicating the name of all successors along with the Iman of the Iman. The petitioner was also declared as one of the successful bidders under the said auction in accordance with the terms. The petitioner demonstrating bona fide intent to comply with the auction terms made a part payment of so-and-so on 30/10. A representation was submitted on Iman for extension of time. So it will end when? 25/10, 10 days? 10 working days will be what?
On fifth, my lord, if I will calculate it on a continuous basis. But if I exclude the holidays, government holiday and Sunday, Saturday, that will expire on 13th of November, my lord.
Saturday, Sunday, you have to remove. You remove Saturday, Sunday is not working day. How do you say so? Do you mention anything? It's a working day. Because why have you used the word working day?
Working day.
They used it.
Has
No,
it
no,
been meant
scheme
differently?
has. At
Any definition, working day will be means the day on which it is worked. You should not have, you said 10 days, why have you used working day? If every day is a working day, then why is the necessity of using the word working day?
Then working, it's been said in 5.3, which might not been.
5.3.
Page number 39.
Would be reckoned as applicable to the respective.
Within 10 working days.
Yes.
So 10 working days after the date of closing of the e-auction, 10 days will be recorded as applicable to the respective office where the payment deposit is required to be made. So it is therefore Chhath Puja won't get the benefit
My lord.
in
Sunday.
view of days. But Saturday, Sunday will obviously get the benefit if it's not a working day.
My lord.
And also if it is a national holiday.
5th of November was, my lord.
What?
5th of November
How?
was holiday, my lord. Guru Parva.
It's not a national holiday.
Yeah, but banks were closed, my lord.
Bank had no business out there. You have money, you pay. You deposit by tomorrow.
My lord, tomorrow is Saturday, given Monday I will deposit, my lord. Monday I will.
Will be violating the terms of the.
No, it will be taken
It's a
as
just
working day. We will say it. Is Guru Nanak as a working day?
Para number 21. Right?
Show me how the working days are to be concluded.
It's not working day, but
Saturday is a working day for us.
What is this?
at para 21, there is a judgment, my lord.
Today is the 12th day.
At para 21, should I read, my lord?
They close it, then they leave it.
Sarah? Whose judgment?
There is a case where the court has allowed the payment even
No,
after.
normally it would have 10 days will be leaving the death day. 25th has to be removed. Huh?
My lord.
So 26, 27, 28, 29, 30. 31. 1, 2, 3. 4. So 4th it is finishing normally. But you remove the
2 Sundays, that's what.
25th. Oh, 25th. How can there be 25th is a Saturday and Sunday is 26th? One and two is again closed. So 4 days is removed. So it will be pay by 10. Pay by 10. 4 days is removed. No, heavens will fall. Man. They are paying to remove this Guru Nanak day and 4 days here and there matter over 5 days he gets.
It's not. It's not 25. It's not. Only was open. Only the 2 Sundays. Otherwise you open. First pay for people.
Then I'll have to issue notice state. Don't do it profit. You at the end of the day you won't get the money. Means there will be delay and not to give the auction area to anybody. So this is going to affect you more.
And I am at the highest bidder, my lord.
So therefore, if we take Saturday, Sunday, because why have you used working day and there is no definition of working day? Because otherwise it would end on 8. 8, 1, 25th. 26 is closed, then 21, 2, 3, 4, 5, 6, 7, 8, 9, 10, Saturday. 9, 10. So it finishes on Saturday.
This, we don't record into our working. That is what.
Understood. I have taken Saturday as a working day. Let's just for example, 25th you have issued.
Only to Sunday, that's only. From 25th, you start.
No, 25th you have issued. 26th is closed.
No,
Right? 26th is Sunday.
Eokin was on 23rd.
Location was 25th.
Eokin was on 23rd.
25th.
23rd.
No, the intimation was given on 25th.
25th.
So, it will start from the date.
From the date on which, after the date of closing of the e-auction. Close of the e-auction happened on 23/10.
But on 25th, allocation was granted to me, my lord. On
No,
25th,
but
I
can't
got
help
to
it.
know ki how much I need
You
to pay.
need to challenge this term then. Can't help it. But
And 28th is fourth Saturday. It's again, I am dependent on banks, my lord. Because if I need to pay them, I need the approval of the bank
Mr.
manager.
Counsel, you have to also understand that if I increase your case, every time a person will come. It will be floodgates. Today is one day, tomorrow is 2 days. Better off move those authorities. They are more lenient than me.
My lord, I've already submitted representation. Anyhow, they will get benefit. The session money will be saved, my lord, because again, e-auction will be held. I am the highest bidder, my lord. Nothing will be like.
Okay, in the meantime, if you deposit, deposit. If you don't deposit, matter over then. But anyways, it will be counted from 23. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Fourth is finishing. If it is taken on 23rd, removing 23rd. 5th is closed. Today is 6, 7. You do whatever we issue notice, no stay. You do whatever you feel like. But I think this is a case for dismissal. But at 4:40 to dismiss your case would be very bad. So
One day difference
I
will not.
become lenient and issue a notice. But at the end of the day, I can't help. No, dismissed. Withdraw or dismiss?
My lord, withdraw.
Huh?
Withdraw, I will withdraw.
And learned counsel appearing on behalf of the petitioner, or Mr. Learned, so-and-so, learned counsel appearing on behalf of the petitioner, and Mr. MZ Ahmed, the learned senior counsel, assisted by so-and-so, who appears on behalf of the Northeast Coalfields. The counsel appearing on behalf of the petitioner submits that the petitioner would like to submit a representation to the authorities concerned for extension of the period, taking into account that the petitioner is the
We
highest
have already
bidder.
submitted representation, my lord.
Have already submitted the representation before the concerned authorities, and taking into account that the petitioner would be is the highest bidder, there is a likelihood that the said representation would be considered. He therefore submitted that the petitioner would not like to press the instant petition. Taking into account the above.
I think this should be directed to decide my representation within a week, my lord.
Withdraw with a decision direction.
Oblige me.
Yes, any matter
Oblige.
which is urgent.
Lordship, contempt case on my lord request, it was listed. Lordship, can it be on Wednesday, madam?
40 to 49.
42, 45, madam.
What is that?
My lord, here, my lord, the direction was given by the Sonawal Control.
Mr. Samaria, are you not the Assam Seeds Corporation lawyer?
Yes, madam.
Planning Council?
Yes.
There are many matters which have been filed today where Assam Seeds Corporation.
But
has-
sometimes what happened, my lord, we have given letter to the joint register, my lord, to serve the copy, but instead of that, my lord, that has been bypassed, my lord. Anyway, my lord,
Anyways,
but I will follow. My Wednesday, my lord,
wait. What do you want?
my lord, Wednesday, my lord. 43, 42.
Don't have it on Wednesday because Wednesday again this
My-
matter.
Friday, my
This matter is creating a.
No problem.
There are two
My-
matters which have Derailed. Yesterday there was this matter which derailed, today also this matter derailed everybody's proceeding.
My lord, Friday, my lord.
Friday, okay, I'm not there. I have it.
Then, my lord,
14
prior to that.
42, yeah, on Friday. 14.
Lord,
Item 32, my friends would be seeking some time to file an affidavit in reply. If your lordship kindly fixes the date.
Holiday listing matter, termination and stated listing.
Oh, that, where you have extended, though have removed the holiday listing, but he was, did you file an additional?
Yes, filed it yesterday, ma'am. Filed it.
Mr. S. Dotto, the learned senior counsel submits that the petitioner have filed an additional affidavit challenging
The appellate order.
the appellate order, whereby the petitioner, although whereby appellate order. Mr. Endeka, appearing on behalf of the NRL, no? Submits that he would like to file a reply thereto. Taking into account the above, list this matter on 21st of November 2025. In the meantime, the reply be filed. 21st, possible? Okay.
My lord, item number 62, my lord, it's a contempt case already complied with, my lord, may be closed, my lord.
Okay, it is filable, huh? Ms.
64.
S.B. Chaudhary, the learned counsel, appearing on behalf of the petitioner, submits that the order dated so-and-so passed in WPC number so-and-so have been duly complied with, and as such, the petitioner would not like to further proceed with the contempt proceeding. Taking into account that the order has been complied with, the contempt proceeding stands strong.
Complied.
With regard to item number 60 of today's supplementary list. 60 of supplementary list.
60.
One. May I pray for
60. What is this?
pertaining to this central destitute home where the people are seeking the benefits of Prime Minister Housing Urban Yojana. The affidavits have been filed from one of the respondents and also respondent number 1. But
You have filed reply?
no, I have not filed it.
You want to file reply?
But the affidavit of the Department of House and Urban Areas would be required, my lord, here, because they have filed the affidavit in my favor. Their affidavit filed by Union of India is in my favor. Social welfare.
The state have not filed.
State has not filed.
Ms. Yudas, the learned counsel, appearing on behalf learned additional senior government affairs, submits that the respondents would file the affidavit within 3 weeks. List this matter on 5th of December 2025. In the meantime, the affidavit be filed on or before 3rd of December 2025.
May I please the lordship, my lord, in item number 61, my lord, the interim order is there till today, my lord. So it may be extended, my lord.
Item number 61. Due to paucity of time, the matter could not be taken up for disposal. Accordingly, this court directs the matter to be listed again on 26th of November 2025. Interim order passed earlier shall continue till then.
Obligement.
Maybe little lordship,
61.
Huh?
Item 61.
61.
One, I have received one instruction from.
Wait. Mr. Bora. Yes, what do you say?
I have received one instruction from the circle officer and lordship. 61. It says a position was given. But still lordship, they have mentioned some other cycle officers also. From that part, I need to take the instruction.
No, there are 4, if I'm not wrong.
From Mongolia.
No, there is one, you see, pursuant to certain orders being passed.
Yes.
No, he had filed the petition, if I'm not wrong. He has filed the petition, and in that petition, there was for a long period, there was nothing being done. Therefore, he filed a petition before the commissioner and secretary. If I'm not wrong?
Yes, madam.
And commissioner and secretary, after filing that, commissioner endorsed it to the district commissioner, directing the circle officer to report the circular, to make a report. The district commissioner then writes to the circle officer. Circle officer writes to the 4 circle officers for doing it, and this has not been done. But on the other hand, they have imposed for the earlier period certain amount, although for the last 11 months or 9 months, they have not handed over the possession.
Yes.
Isn't it the case?
Yes, my lord, yes.
I remember.
Yes, my lord.
You get your instruction. This is not done. We have to set aside this anyway.
Common pay circle cannot handle.
No, we are not, no, that's a different thing. Whether you hand over or not, that is another aspect.
Yes.
But you can't impose that is another thing. So you are therefore to recall, that is what you should do. Because you see the ADC concern now under what has happened after he is now, it seems he's scared with the commissioner and secretary's order. They're being directing for compliance and to report. And therefore, the district commissioner must have said it to him. Now the ADC says that, oh, what have I done? So now he's imposing upon him, although handing over has not been done till now. Then if it is your very instruction out here that that circle officer is writing to the other 4 circle officers about this for handing over and all, then in that case, that means it has not been handed over. And if it has not been handed over, how can you impose upon him to make the payment for the 9 months?
Yes.
Isn't it your case?
Yes.
Yeah, okay. Okay, we finish it up tomorrow. How much time? I hope. Mr. S.R. Burwa submits, appearing on behalf of the district administration, submits that some more time is required for obtaining the instructions to item 61. So taking into account the above, list this matter on 26th of November 2025, on which date the circle officer, on which date the district administration of which district? Dorong shall apprise this court as to when the petitioner have been handed over possession of the fishery in question without fail. Because the interim order passed earlier shall continue till the next date.
My lord, can it be on 28, my lord? On 26, I have.
Okay, 28.
May please, Lordship, item number 36, my lord, interim order as on today, my lord.
What is that matter about?
Matter, my lord, Parghat, my lord, petitioners, my lord, name was recommended, but tender process was cancelled, citing ground that a criminal case is pending against the petitioner, my lord, that case, my lord.
Hmm?
A criminal case is pending against the petitioner.
Oh, that one where
Yes, ma'am.
it is not of moral turpitude.
Yes, my lord.
That
That-
is your case.
yes, my
Okay. Okay. The PNRD is there, no? Also, due to paucity of time, the matter could not be taken up for disposal. And further, no affidavit has been filed.
If it is filed by tribal respondent, my lord. Yes, my lord.
By the PNRD department.
No, my lord.
So in that view of the matter, list the matter on 26th of November in time order passed earlier shall continue till then.
Obliged,
May I please, your lordship? In item number 22, lordship, next week, any date may be fixed, lordship. 29.
29? Oh, 22 I finished, 29. R.Ali. What is the matter about?
Lordship, petitioner is work as a traffic license porter, but the respondent authority, petitioner's license has been cancelled, lordship.
List this matter again on 19th of November 2025 for admission.
Lordship, item number 28, my lord.
Hmm.
This matter may be listed in next week, any date, my lord.
Okay.
Item number 28.
At the request of the learned council, the matter stands adjourned to be listed on 14th of November 2000.
Most obliged.
Lordship, I am hearing for order number 456 in item number 31. Vilasipara Municipal Board. We have to file affidavit. The matter will be come up after 3 weeks, lordship.
Okay, Mr. So appearing on behalf of the respondent numbers 4, 5, and 6 for an accommodation to file the reply affidavit in opposition. Accordingly, list the matter on 3rd of December 2025. So in the meantime, the affidavit in opposition be filed by the respondent numbers 4, 5, and 6 without fail by 28th of November 2025.
Lordship, my name is not reflected in odd list, so it may be reflected.
No, you do it. That I'm not going to do. Next.
Let me clear, Lordship. Item 40, Lordship.
Yes, what is it?
With the contempt Lordship and last occasion, Lordship, the opposite side, Lordship, submitted that the order passed by your Lordship has been forwarded to the judicial review.
Judicial?
Review.
What
Judicial
review? Okay, item 40, list this matter again on 19th of November 2020. Orders.
Lordship, item number 51, Lordship, I am for the petitioner, Lordship. Lordship, the department has filed. Lordship,
Why the matter has come up? Orders?
Orders, Lordship, notice.
চাইছিল নেকি এখন 51 কিয় আহিছে কিয় আহিছে অৰ্ডাৰ সহ এখন বনাইছে Fifty-one is different. 51 here, affidavit filed on behalf of the responding flag A. Affidavit regarding the stay is filed. Service not complete upon respond number 8. Service is not complete upon respond number 8.
Dated 4/11, Lordship. As per the speed post, Lordship, the notice is served, Lordship. And in the justice service, Lordship, I also served the notice, Lordship, and I filed active,
Now,
Lordship.
what about respond number 8?
Yes, yes. I served dusty notice, Lordship.
But upon respond number 8?
Yes, upon it, Lordship.
Okay. This court duly takes note of the affidavit of service filed by the petitioner on 4/11/2025. And from the said affidavit, it is seen that who is the respondent number 8?
Lordship, Shahjahan Ali, Lordship.
That the respondent number 8 duly received the said notice on 18/10/2025 in presence of witnesses. Accordingly, this court therefore deems that the service upon the respondent number 8 is duly complete. So list this matter for admission on 14th, on 19th. 14th I won't be there, so I'll fix it on 14th.
Lordship, the department has filed affidavit of eviction.
Okay, on then we can finish it off
Lordship,
on
after-
19th of November 2025.
Lordship, I will file it, right?
In the meantime, the petitioner is given the liberty to file reply
Lordship.
by admission. I go, huh?
Right.
Anything more? Yes.
Lordship, item number 62, the petitioner has mentioned order has already been filed. In the order
60?
62.
62. Oh, they have withdrawn, something has been withdrawn.
We have complained, they said they have received.
Your name, we can put it.
Lordship, Dina's name, may I kindly.
Mr. Dinath appears on behalf of the contempt respondent.
May
Yes, what is
my
your-
lord, may I mention item 37?
27.
37.
37. Yes.
My lord, in this matter, the state was instructed to give its instruction as to why the tender process is not being completed in a time-bound manner.
I remember.
My lord, this may be taken upon,
Mr. B. Gogoi was asked to obtain instruction.
yes, my lord.
List this matter on Wednesday. Will you have it on 12th
Oblige, my lord.
for orders? For admission.
Oblige, my lord.